Are there folks on the phone? Can they hear us? Okay.
Hi, hello?
Wonderful, all right.
Do I have someone with me now?
Yes. You're with us. I'm not sure.
Okay, great.
Is there anyone else, or is it?
I think it's just me. They may be on mute, I suppose.
Yeah. Well, we're gonna do. We're gonna save some time to do some introductions. So if there are other people on the phone, you'll get a chance to chime in and unmute yourself if you want to introduce yourself. But welcome everyone. My name is Sarah Brennis. I'm the program director at the Advocates for Human Rights. And if you're in this room, you're here with us to learn about asylum law. So hopefully everyone here is on board for that. And Allison, you want to introduce?
Yeah, hi, I'm Allison. I am a staff attorney in the Refugee and Immigrant Program, and in that capacity, I work with pro bono attorneys and legal support staff to help you all advocate on behalf of asylum seekers. So thrilled to see a great crowd of folks today, and really excited to work with you to advocate for asylum seekers we work with.
And I know we've got a mix of folks today, people that this is your first time being exposed to asylum law, others getting a refresher, others just taking pace and they're ready and they've got context of folks they might be working with. And we also have some special guests in the other room. We have some visitors from the Moscow Community Center in Russia that have been with us this week, and we've been exchanging tips and ideas on how to support folks in the LGBT community. So they're listening in the other room with some interpretation, and we're going to try to feature some case samples in our training today that focus on cases involving claims based on sexual orientation. So that's an extra added bonus that we don't always get when we do these trainings. So I do, just because we do want to get a sense of where folks are at in terms of their training and experience, just want to take some time for people to introduce themselves and let us know about what your interest is or your involvement or experience that you have with asylum claims. So you can start right here.
Hi, I'm Aklilu Dunlap. Some 27 years ago, I was a volunteer law student with your predecessor. I think it was Minnesota. I can't remember the exact name. In any case, I have a practice that is primarily real estate and bankruptcy. But I did not grow up in an America that is as intolerant as I feel right now. So for the past couple of years, I've been doing naturalization work as a volunteer attorney, at least 2 or 3 cases a year with legal aid, and I want to add asylum law. I should also just say that I'm an adoptee from Eritrea, and Eritrea has a horrific living situation, which is producing the greatest number of asylees on a per month rata, I think.
Thank you.
My name is Mikal Garber. I just retired from being an attorney for the state of Minnesota. I have absolutely zero experience in immigration other than being an immigrant myself. But I'd love to learn and hopefully be able to help.
Wonderful. Thank you.
I'm Rachel Taylor. I'm a patent agent at General Mills. I am working with Josh Burke here. We just picked up, for me, my second opportunity to help someone. So I've worked on a case once before with Matt Lewis, who has worked on several of them.
I'm Josh Burke. I'm a trademark copyright and licensing attorney at General Mills with 0 asylum experience, except that now I have a client who we met with earlier this week. And pro bono opportunities are hard to come by in-house. And so our colleague Matt Lewis has done 14 of these cases and somehow convinced me to do this one. So.
All right.
Hi, I'm Gary Weinstein. I'm a partner here at Fakery Baker Daniels. My practice is primarily intellectual property licensing and other transactions, and I have 0 experience with asylum work, but I'm interested in learning.
I'm Barb Pratt, and I'm a paralegal here at Fakery, and I do not have any experience with asylum work.
I'm Caitlin Abram. I am a partner in the wealth management group here at Fakery. I do some litigation work, and I've had a little experience with a Violence Against Women Act case early in my career, but I've never done an asylum case. I'm really looking forward to working on something.
I'm Glenn Brushwine, a primarily retired attorney. I have 25 years of civil litigation and prosecutorial experience, and Allison and Sarah are helping me through my first and second cases.
I'm Terry Gould. I'm an immigration attorney at Davis and Goldfarb, and I've handled some asylum cases myself.
I'm Milton Nordmeyer. I've been an attorney for 25 years too. Never done any of these cases either. I'd like to give it a shot.
My name is Lori Lukasik. I've practiced with representing victims of domestic violence and sexual assault, and I've had some experience with VAWA and U visa cases, but I haven't done any asylum cases.
I'm Allie Larson. I used to practice, but now currently am a funder of legal aid. And I think that the best thing that I could do to advocate on behalf of the advocates when I'm talking to my board is to understand the ins and out for those who aren't lawyers. Great. So no experience other than the funding experience.
I'm Maureen Malley. I'm a partner here at Faegre in our benefits and executive compensation group. I did one asylum case on behalf of some Somalian immigrants about 10 years ago, and then I got into other areas of pro bono, and now I kind of wanted to get back to this just because it's such a big issue in our society today.
Wonderful. Welcome. Is there an update about
Yeah, so we are lucky to have with us a group from the Moscow Community Center, which is an advocacy organization in Moscow, and they are going to be actually sitting in the back here just because the interpretation from the other room isn't working. So they'll be doing simultaneous interpretation into Russian in the back. And we'll just speak loud, so if you're not able to hear us, please just let us know. We'll be a little louder. And we also wanted to let you know that this is really, we welcome participation during the entire presentation. This is meant for you to learn. So if there's something that's relevant to one of your cases, or we're going to talk through specific case examples, please just jump in and ask questions whenever you have them. And one other thing that we wanted to mention about our colleagues from the Moscow Community Center is that there's a documentary filmmaker who will be filming them, but he will not be filming anyone else in the room. He doesn't have, obviously, authorization to do that, so he's aware that only the Moscow Community Center participants can be subjects of this documentary.
So can they hear us?
They cannot hear us right now.
Oh, okay.
So they're going to move over here.
Doesn't make sense.
We can hear you, just not very well.
Oh, okay. Do they want to introduce themselves at all?
Это не представится.
Хотите представиться?
Если да, мы, конечно, хотим. Говори, говори. Так ты просто представляйся по-русски.
Куда говорить?
Просто говори.
Which microphone should I speak? She said.
Just speak. There are microphones in the room.
Меня зовут Татьяна Винченко, я из Москвы, из Московского комьюнити-центра для ЛГБТ-инициатив, я там директорка.
Center for LGBT initiatives. I'm a director there.
What do we need to do?
Make them bigger? Or no?
Меня зовут Баранова Ольга.
My name is Baranova Olga.
Я, как и все, мы представляют уже Московский комьюнити-центр.
As the rest of us, I represent
Я
the
экс-директор,
Moscow
и
community.
на сегодняшний день я являюсь руководителем различных проектов. Руководителем различных проектов.
I'm a leader of various projects right now at the center.
My name is Ellen. I am administrator of Moscow Community Center.
Ellen is an administrator of the Moscow Community Center.
Мы всех видим.
We see everybody.
Hello.
Okay, just can't hear you very well.
Okay.
Hello to everybody.
Я Андрей, координатор волонтеров.
My name is Andrei. I'm a coordinator of the volunteers at the center.
Great. And do we have folks on the phone as well that want to introduce themselves?
I think we have one. Me, my name is Andrew Nordic. I run a small copyright and trademark practice.
Great.
Matt Lewis on the phone, General Mills as well.
All right. Anyone else going once, twice? Okay. Okay, so are we sticking with them in the room then, or with Heather?
I think Jennifer and Amy will pick your name.
Okay, so we should keep it.
Yeah, and we can also maybe folks around the webinar.
Okay, so is this the mic that picks us up? Okay. got
And
it.
they're on both sides except for this side.
Oh,
Thanks so much.
Okay. All right, so
All right,
it's your magic
Sarah,
button.
sorry to interrupt. We're going to have to move into the room. So apologies for the interruption.
No, making it work. Okay. Do you know what he pushed to make the presentation go up?
I don't remember which computer we're on.
The room PC, maybe.
Did folks on the webinar already introduce themselves?
Yes.
They did?
Yep, there are two people that did.
Perfect. Okay.
And do you,
Welcome.
do
Yeah.
you want to introduce yourself? We just went around it.
Oh, I'm Shelley
Introductions.
Timmons. I'm the pro bono counsel here at the firm.
Yeah, do you want to introduce yourself?
Yes, I'm Laura Cease. I'm a volunteer.
Thanks for being here.
All right. Well, thanks everyone for your patience in making this work. It's always, having international visitors is an exception, but we do continue to try to make our trainings more accessible to folks. We do serve people from Minnesota, North Dakota, South Dakota, all in greater Minnesota, and so really trying to find ways that people can loop in when they're not here in the Twin Cities is really important. So thank you for making that work, and for those that came today too, because there is a lot of value in being in the room and being able to do some networking as well when you come to these trainings. Okay, so just a little bit of context before we dig into the asylum work about the Advocates for Human Rights, for those of you that might not be familiar with us. We're celebrating our 35th anniversary this year, and we are a human rights organization, and all of the work in our different programs ties into the Universal Declaration for Human Rights. So in our work in the Refugee and Immigrant Program, we're working with the right to seek asylum and protection from persecution in different countries. We also have programs that work on international justice, ones that work with diaspora communities so they can continue human rights work even if they're outside of their country. We've worked on some transitional justice work on truth and reconciliation commissions for countries coming out of civil war. We have a women's program that works on issues. In the last several years, we've been working in Eastern Europe with partner organizations that are working to do fact-finding about domestic violence, promote domestic violence laws, and implement them in the countries. We also have a research, education, and advocacy project. We promote human rights to get human rights in the classroom. We worked on curriculum issues. We've also done other research and a lot of fact-finding in the state of Minnesota to find out how welcoming communities are. We've also done reporting on human trafficking. About 10 years ago now, I think we came out with a report on sex trafficking, and just last year one on labor trafficking as a human rights issue. And one of the things that's integral to all of our programs is involving volunteers. So we are involving mostly attorneys, but also work with interpreters, with educators, and with other individuals who can plug in to be part of the human rights movement. And so that's really essential to the work that we do at any level. And so we're glad that you're here to learn more about volunteering with our program. The Refugee and Immigrant Program is the one part of our organization that does direct legal services. We have about 600 open asylum claims right now, and working about 85% of those cases are placed with volunteer attorneys that we train and support in order to help as many people as possible. And one of the other exciting things that I'll mention that we've done in the last several years is trying to integrate all of our programming so that we just sent some reports to the United Nations a couple of weeks ago that integrated stories of our clients to tell the United Nations and report on countries that they came from about the human rights violations that they experienced there. And then in the same way, giving our clients the opportunity to learn about how they can continue their work if they were working in the area of human rights in their country. So really being more integrated in the work that we do. So we're happy as you're working on cases and getting to know clients to talk about other ways that your clients can be involved in the human rights movement as well. But today we're going to focus on the nuts and bolts of asylum law. And to tee us up to get some context, Allison's going to share a couple case examples to get you thinking about some of the fact patterns that we might see in cases involving asylum seekers.
Yeah, so you have in front of you 2 case examples, and these are actually real cases. The reason that we're able to share, of course, with our own clients, we're very, very careful about not disclosing any information, asylum seekers information, like all clients of attorneys, is very sensitive, particularly sensitive given the need to protect their information from persecuted governments. But these are individuals who were before the 8th Circuit of Appeals, and so they had good outcomes in their asylum cases. So we wanted to share with you the facts of these cases, not only so that you can use these cases as you're advocating for your clients, but also so that you have kind of some facts to hang the information we're sharing with you on. We're focusing today on asylum cases as related to LGBTQ asylum seekers, so that we can kind of share how those cases in particular are handled by attorneys and what advocacy might be particularly relevant to those cases. However, the advocacy strategies and information that we share will be relevant more broadly to other case types. So if you take a look, can I have a volunteer who would like to read about Ms. Nabalwala's case to us? Anybody want to be brave?
I can do it.
Okay, thanks, Laura.
Okay. Yes, Ms. Nabalwala, a Ugandan citizen, first realized that she was a lesbian in high school in Uganda. During her senior year, she came out to her parents, who became angry and held a family meeting and tried to find a quote-unquote solution in which she was abused by an aunt. During college, she joined an advocacy group for LGBTQ rights called Wanda Gaya. The group was attacked by an angry mob, and Ms. Nabalwala was hospitalized as a result of injuries during that attack. 2 years later, when her family learned she was still lesbian, her father assaulted her, her family forced her to have sex with a stranger, and then disowned her, and she became homeless. She then came to the U.S. on a visitor visa and is seeking your help to apply for asylum.
Laura. So, and then, well, as we're going through, as we're discussing different concepts, you want to think about how you might prove those concepts for each of these asylum seekers. Would anyone like to read Mr. S.'s case description? Okay. All right. Well, I don't want to have any unwilling victims. Okay, perfect.
Re-raising your hand.
Yes, sure.
Thank you.
Mr. Shahinaj reported election fraud to Albanian officials. After he did so, police officers beat and raped him, threatened to harm his family, and made repeated homophobic insults while harming him. He is not a member of any LGBT advocacy group and has not disclosed his orientation to his family. The immigration judge reviewing his case commented that he did not dress or speak like or exhibit the mannerisms of a homosexual, and therefore denied him relief, stating that he did not believe that Mr. S. could credibly establish his own sexual orientation. You have agreed to represent him on an appeal to challenge the basis of the immigration judge's credibility findings.
Yeah. Thank you very much. All right. So Sarah, you want to take it away?
Okay. So one of the things that we find with volunteers, and echoing what a number of people said in the room about having no experience in asylum law, that's not unusual. I would say most of our volunteers are not immigration attorneys. We tap on them mostly to help with consulting and mentoring our volunteers, but most people don't have other exposure to immigration law. And the asylum law itself, for the most part, is fairly straightforward. What gets complex in asylum law is the procedure. And so a lot of times, a lot of the questions that we get from volunteers isn't as much about making the case, but it's how the procedure's moving forward and navigating some of the documentation. The credit goes to Human Rights First, another organization that works with asylum seekers that came up with this infographic that I think does a really good job of kind of conceptualizing the different ways that people can receive protection. refugee protection. The first and probably one that many people are familiar with is the refugee resettlement process. And so those are folks that we aren't working with because they've already gone through the legal process and have been recognized legally as refugees outside of the United States, and then are subsequently resettled here with a lot of our resettlement agencies throughout the U.S. That assist with getting them connected with housing and benefits and finding jobs because they come into the country with those permissions already.
So does that happen like in refugee camps and that kind of thing?
Right, so they would process and go through the interviews, very similar to the asylum interview, but they would do that at in a refugee camp and then subsequently be resettled here in the U.S. So those are folks that we don't usually work with because they've already gone through the legal process. The other three categories are people that we might represent in our refugee and immigrant program. The first is the affirmative asylum process. So refugees come in as refugees. Asylum seekers, they can come in as visitors, they may come in as students, they may come in on temporary work visas, they may present themselves at our borders or in our airports asking for protection. And so depending on how people come in, they'll be in one of these other categories. About 2/3 of our cases are affirmative asylum seekers. A large portion of those have come in as visitors, others come in as students. They may or may not have gone to school. The reality with asylum seekers is you do what you need to do to be safe and get out of your country. And the asylum law recognizes that. So in other contexts, it might be problematic if they didn't go to school. And certainly is something addressed in the asylum interview, but the law recognizes that people do need to do what they need to do to be safe and keep their family safe. So in an affirmative asylum application is one where the person prepares the application, under the law needs to file within 1 year of entering the U.S., of their last entry, or meet one of the exceptions if they're filing afterwards. And then they're scheduled for an asylum interview and receive a decision after that. Maybe they're granted. If they're not granted and they're not in legal status, typically someone who comes in on a tourist visa would have 6 months of status. But by the time their interview happens, they're probably out of status. And if they're not granted, then they're referred to the judge. They get another bite at the apple. The judge gives them a de novo review of their asylum claim, and they present it in a more adversarial atmosphere in that setting. The other group are, well, I'll go down to D actually, for defensive filings. So this is someone who is already in the United States and then are encountered by immigration before they file an asylum claim. Or in some cases, if they're waiting for their affirmative application, they might be put into this defensive process. So they get one bite of the apple taken away and they go straight to the judge. Or it's their first time being encountered and they present their case to the immigration judge. Fewer of those cases we're seeing for people, largely because people have been here for several years and it might be more difficult to overcome that 1 year filing deadline. The other group that makes up probably about 1/3 of our cases are people who come in as arriving aliens, and they're arriving asylum seekers. It may be people that attempted to enter the United States without inspection, or they came to the border and asked for protection, or were at the airport and disclosed that they're fearful of returning to their country. And so then they're put into what is really sort of a mini asylum interview called a credible fear interview. And then if they pass that interview, then they get to present their full asylum claim before the immigration judge. Procedurally, these cases can be a little more complex. There's also a paper trail there. So they've had an interview with an immigration officer right at the border, and then they had a credible fear interview with an asylum officer. And all those encounters are documenting pieces of what their claim is, a fear of returning. And then ultimately they would present their claim before the immigration judge, who could grant or deny the claim. And then there's appeals process to the Board of Immigration Appeals, and from there we go straight to the circuit courts. So that gives you a little overview in terms of the types of claims. We represent individuals from over 50 different countries. I would say most of the arriving asylum seekers are from Central America, but we also do have individuals who come from different countries in Africa. I think we've got some Somali asylum seekers from Cameroon that have made the journey through South America and came to the border to ask for protection. So looking at the two case examples we have, where do you think the two? Well, let's start with Miss N from Uganda. Where does she fall in this chart?
She'd probably be in the affirmative asylum category.
Right. So she came in with a visitor visa, and so she'd be in that track B and making affirmative claim. What about Mr. S?
I guess he'd be in D, since he is appealing the decision. So, is that right?
Yep. So, I guess the facts don't really tell us. He may have filed under B and then was referred to the judge, and now the judge has denied the application, and he wants to appeal to the next level, to the Board of Immigration Appeals. So that gives you a little sense of where they are.
Under process B, is it more or less administrative where the petition for asylum is reviewed? I don't suppose that it's a judge that's reviewing the petition, or is it?
Under B, so they're asylum officers, which is a division of the U.S. Citizenship and Immigration Service. So there's specially trained officers that sometimes lawyers, sometimes not, that would review the paper claim that's filed, and then they conduct the interview. It's meant to be a non-adversarial interview in a small office. They're typing notes on a computer. There's your applicant, the attorney, and interpreter is usually all that's there. In that context, in some cases, there might be other witnesses. If we've got a case for a child, maybe a parent would offer some additional information, particularly the child's very young. But in most cases, it's just the applicant that's testifying to the facts that they put in the written application.
How long would that be after submission of the petition? And then secondly, I know it's...
We're only laughing because it's changing a lot.
Yeah. No, valid question.
And then my understanding is that interviewer recommends approval or discourages approval. Is that right? Does he or she have decision-making authority?
Well, so they've got supervisors. They'll make a recommendation to the supervisor, and then will issue a decision on the case.
Okay.
But it is sort of, yeah. I mean, they aren't the only person weighing in on the case. And in terms of process, both the courts and the asylum office have been overwhelmed and underfunded in terms of addressing the claims. So I would say 6 months ago, if someone walked into our office, we'd tell them that if they filed their claim today, it will be 3 to 5 years before they have an interview. In the regulations, it says it's supposed to be 6 months. And just last month, the asylum office stated that its new policy is now for anyone who's filing after January 2018, they will be interviewed. For us, we're a circuit ride within 6 months. So that's very different and also has an impact on people who filed claims a few years ago and are waiting or now even lower on the priority list. That said, there can be requests to expedite the interview, but it is rather unpredictable. And you get notice 2 to 3 weeks before the interview happens. So you might be waiting on a case for a while, and then it gets called for interview. And this is also another reason that we've been trying to work with volunteers. It is a long commitment to stick with a case that long. But, if someone is able to step in and help get the application filed, we're also open to doing co-counsel type situations where then we would be prepared to handle the case and reach out when the interview is called if you're still available, and if not, we could represent the person on the interview. Because a lot of the work is on the front end in preparing that application. And really, probably the bulk of the time that you'll spend with your client is working on the affidavit to get the balance of enough detail, but also recognizing that all of our clients have gone through trauma, and trauma impacts one's memory. And so being able to give them flexibility to tell their story in enough detail to meet the standard, but also not jeopardize their credibility when they go in for the interview.
I have two questions. First, so while people are waiting all of this time for an interview, are some people detained and some people not? Assume?
Yes, that's another question of immigration detention. So typically, if someone's in this category C, they are detained while they go through the credible fear interview, and then they're eligible for parole, so they can be released while they proceed with their case before the judge. It's not uniform, and we've really seen sort of different practices in terms of, sometimes people are released before they even have the credible fear interview, if they're at the border, depending on where you go and what their capacity is really at the different ports of entry. We do also encounter some people who they may have come in at the airport and then were questioned about whether or not they really were coming as visitors, and then it comes out that they are actually planning to seek asylum, and then they might remain in detention. And so we do have a small portion of our clients that are seeking asylum are in immigration detention. And we can talk more about that later as well. We have county jails that house immigrant detainees. And so that certainly factors in. And if there are even more time-intensive cases, but a little more predictable. It's a shorter period of time, but you think about what you need to calculate to go visit your client, and there's a lot more going on in terms of conditions in detention that are on top of the actual case. But certainly, for folks that are comfortable in that realm, we're always looking for more people that are willing to take on those cases, because those clients have the hardest time finding an attorney out of anyone.
I think there's one other thing. Now, if in the credible fear interview, if they're denied, is there an option for appeal at that stage as well?
So they can ask the immigration judge to review that decision.
Okay.
And if the judge vacates the negative credible fear finding, then the person could proceed to ask for asylum. If not, then they would be issued an expedited removal order.
Is the parole on bond?
No. Okay. No, not usually. Yeah. But it is at the discretion of the immigration customs enforcement. So if you've got someone who's come in and as arriving alien, the judge is powerless to decide whether they'll be detained or not, which is one of the complexities.
I will add that there have been more bonds and higher bonds issued lately for folks who are trying to come join their family members. We even had a young woman with no criminal record whatsoever, who had already filed for asylum while in detention, had identified family members that she was going to live with here, so clearly not a danger, not a flight risk, and she was charged a $40,000 bond to come join her family here in Minnesota. So we are starting to see that, but I think typically we haven't seen that in the past.
Yeah. And there are some other factors are involved, but sometimes border entrants are not charged as arriving aliens, and so then they would be eligible for bond. But that's something that's usually we'd see through the charging documents that come through.
I kind of had the same question of what people's status is while they're waiting for this 3 to 5 years, and kind of assuming someone not in detention, I mean, they typically just go live with family or friends or someone that they know, and then they're just kind of everything's uncertain for them during that time frame.
Yes, lots of uncertainty, and we're going to circle back and talk more about that, because that is something, there's a legal case and there's a lot going on for your client, and some of the different things that we do to try to help support people while they're going through the process. All right, so now swooping into the actual substance of the law, there are various sources of asylum or various pieces of the law that inform what the standard is for asylum. It gets its inspiration from the Refugee Convention and the subsequent protocol, but it is part of our Immigration Nationality Act the statute on asylum, and then interpreted through regulations and a lot of case law. And in all the areas of immigration law, asylum law has probably the deepest well of case law that's helping to inform us on a lot of the issues that the statutes and regulations just don't give us enough guidance on. So that's really important to be thinking about, particularly when you're working on some of the cases where it's a little less settled. A lot of our cases coming out of Central America involving gang violence are ones where the law is constantly changing, and it's really kind of an exciting area to see how we and others across the country are really working to make sure that those children and families are protected. So I'll turn it over to Allison to jump into the heart of the matter.
Yeah. So this piece of law will be your most important guide as you are representing asylum seekers. As Sarah said, there's a lot of case law, but really the most important statute is the asylum definition. So your client, with your help, will have the burden of meeting every aspect of this definition. And this definition kind of breaks down nicely all the different pieces of what an asylum seeker or a refugee has to show. So for an asylum seeker, they have to be outside of their country of origin and will be here in the U.S. And they have to show that they're unable or unwilling to return to their home country or last country of habitual residence because of persecution. So we'll talk a little bit about what is persecution, what harm rises to the level of persecution, or a well-founded fear of persecution. So could either be past persecution or a well-founded future fear, which we'll talk about a little more. And it has to be on account of, so there has to be a certain level of connection between one of these protected grounds and that persecution. So on account of race, religion, nationality, membership in a particular social group, or political opinion. And so you might think, well, what's membership in a particular social group? The other things sound familiar to me. We'll talk a little bit more about what that is. But this is the definition of refugee codified in our U.S. law. And you can see kind of here the elements are broken down a little bit. And really, oftentimes it'll be your client's testimony. As Sarah was saying, the affidavit is the most important part of the applicant's application oftentimes because it lays out the details, the facts that show that your client is credible and has specific incidents they can recount of persecution and specific facts that show the connection between the persecution and their protected grounds. Oftentimes your clients will not have a big stack of documents to show why they qualify for asylum, and so their testimony will be the most important part. You know, asylum seekers are often fleeing with maybe the clothes on their back to be safe, and so documentation is less common than in other areas of law. And Sarah's going to talk to us about persecution.
So persecution is one of those areas that we don't have a neat, tidy statutory definition, but our case law tells us that it's the infliction of death, torture, or injury to one's person or freedom. And we look at it sort of in the different levels of the spectrum. It's not mere harassment or discrimination. It can be one specific incident that was persecution, but it can also be cumulative harm. So even though harassment discrimination isn't enough, if it's happened repeatedly over a long period of time and maybe in different aspects of someone's life, then it could constitute persecution. And I would say in the cases, the LGBT cases are probably one of the common ones where that is the claim. Maybe there is one really egregious incident that happened to someone, but oftentimes it's a lifetime of harassment and discrimination that they suffered that cumulatively would amount to persecution. So thinking about, and then when you talk with your client, you're talking about their childhood experiences and really trying to dig up some of the most painful incidents that happened in their life that create the entire picture to show that this person was in fact persecuted. It might also be other incidents that there's very settled law. Anytime someone's been unconscious or if they've suffered sexual violence, pretty clear to identify persecution in those cases. And then, of course, probably about 40 to 50% of our clients are torture survivors. And so there's the testimony about their torture. Oftentimes they're not going to have, in any case, it'll be difficult to actually find corroborating evidence, but sometimes the client's body will be the testimony, and there's different physical exams that might document different scars and things people have, as well as the mental health impact. So a lot of times we're working with psychologists and other mental health providers to help understand what the impact of the harm someone suffered had on their life. Did you want to add something?
Oh, just
yeah, to go back here. And then the one.
Sorry to interrupt here. This is Andrew Norwick. I'm just going to have to drop off the call. Sorry about this.
Oh, okay. Thank you. And then the one other point is that punitive or malignant intent is not required. So if you're working with someone and the harm someone suffered was family or community that claimed that they were harming someone or trying to be corrective about their sexual orientation and didn't mean to harm the person, that could still be considered persecution. Or we see this also in cases involving female genital mutilation, where the community sees it as a cultural rite of passage, but it was harmful to the individual, and that's enough for it to be considered persecution. So looking at the examples,
Sure, we have a question back here. Yeah.
You mentioned repeatedly in the examples of sexual orientation. Which on account of classification does that fit into?
Yeah, we'll delve into that
Okay.
a little bit later, because that is a key part of it, and luckily now fairly settled in the law. But yeah.
Amy.
Yeah.
Can you talk a little bit about how the law in a particular country intersects with persecution? If the law itself prohibits certain conduct that would affect a particular social group, is that enough, or do they have to show that they, some personal connection to that? Like, we have laws that criminalize, in some countries, that criminalize consensual adult same-sex conduct, for example. Is that enough to have a client say, the law prohibited me from doing this?
Right. In some cases, it can be, and I think a lot of times it would be, that would be one of the factors to consider. But I think there's, if it's a law that's there but has not been utilized at all, it could be problematic in the case. But for a lot of these cases, the client has one story, but then there's a lot of objective evidence. So, looking at the incidents when the law has been utilized or other harms to other people is really going to be relevant. And we'll talk more about the corroboration piece and kind of how that factors into it in some of the examples later on.
Yeah, so looking at your examples, so remember Sarah said that a variety of harms can qualify as persecution, torture, discrimination in a variety of aspects of life, housing discrimination, employment discrimination, threats. So when looking at Ms. N's case first, what incidents do you think you would want to highlight as persecution? And remembering that it's a cumulative definition, so even if an adjudicator doesn't think that one attack is enough or one incident is enough, you want to present every single incident so that the adjudicator sees the full picture of the persecution. Yeah.
I think she has two prongs. One would be societal. Her social group was attacked by a mob, and the other one, it appears, would be familial.
Yeah, so she suffered an attack, and what's the persecution from her family?
Well, the physical assault by her father, the sort of emotional abuse from other members, and the rape or forced sex orchestrated by her family.
Yep, exactly. So that's a good point. Emotional and psychological harm can be important to the overall picture. Are there other things that folks noticed in addition to that? I think that's pretty comprehensive.
She's homeless.
Yeah, exactly. So she's homeless. She was forced to, she has nowhere to go. When her family can threaten, you can show there's nowhere else that could support her. There's no community center that can help her to find housing.
It appears to be ongoing and unlikely to stop, given that the abuse happened before going to college, at college, and then after college. So it's unlikely to stop because her orientation is not going to change.
Right. She has this long history of cumulative harm. All right. And Sarah, do you want to take it away from Mr. S? What harm does it?
Oh, well, maybe we'll go back to him for
Okay.
another one. Okay, so as we mentioned, in order to qualify for asylum, the individual has to have a well-founded fear of persecution. Our case law says that's a 1 in 10 chance that they will be persecuted. Gordon sometimes feels like it needs to be a little bit more, but that's the law at least. And there's 2 parts of that. So one is the subjective fear that the individual has, and that one's usually not too hard to establish. The one thing is just noting, wanting to, saying, well, it seems nice to be living here in the United States, and better than my home country is not going to be sufficient. But it does analyze, does the person have an individual fear that's subjective to them in their situation? The other piece that's a little more challenging sometimes to establish is the objective fear. So you need to establish that, okay, this person is fearful, but is it objectively reasonable that they are fearful? And how are we going to show that? We're going to use the facts in their case that support their individual fear, and then other objective evidence or testimony. So these are going to be country reports. The first place the asylum adjudicators look to is the U.S. Department of State issues country human rights reports on countries each year, and that's going to be their starting point. And there is a section that talks about women, a section that talks about LGBT community. So there'll be at least a paragraph that talks about what protections are there for individuals, or what types of human rights abuses are occurring. But that's our asylum law is fairly open. The only thing that has been ruled out is Wikipedia. But other than that, if there's other evidence that you think is helpful, you can include it. You know, it can be blogs or different community groups that have written reports. It can be allegedly biased information that will be, you know, given the weight deemed appropriate. Certainly, if you've got a reputable human rights organization doing a report, that's probably going to be given even more weight, or other media outlets. But it's to say that really a lot of that is thinking creatively about what type of information is out there. And, you know, depending on your client may be really helpful in helping you find that information that you wouldn't be able to find, particularly if it's in another language. And there's some other resources out there to do more digging to find information, because sometimes it's not going to be reported in major media outlets, that it's actually information that's really closer to the ground. And so uncovering that can be really important, particularly in places where there isn't going to be a lot of documentation. And then a lot of times expert reports, typically academics that study a particular region of the country or a particular group would be able to offer their expert opinion on what is the condition for this group in the country, and would they suffer harm. And a lot of times might look at the client's affidavit and say, well, based on their situation, I think that, and what I know about the country, I do think that they would be in danger if they returned. Yeah.
Given the constant changing nature of some of the countries that the asylees would be coming from, what is the recency requirement that the courts have established, or at least some of the precedent has established about information like that that's on the ground?
Yeah, so they look at the information current as of the time of the decision. I would say that...
But if you had a report from like a year ago detailing, and that's the most recent you had, detailing atrocious abuses in one of the areas that you were using.
Yeah, that could be sufficient. And with an asylum interview, you know, if you filed the claim a couple of years ago, you're going to try to pull what's recent to show that it's still dangerous for them to go back.
I think it would really depend. It would really depend on, was there something that happened more recently? Like, if you have a report from a year ago, and if the asylum officer does their own independent research, they're going to see it's still the same as it was a year ago. You know, that's the best documentation. That's really different than there was a complete regime change, and things are really different on the ground. So if there's a more recent situation, you certainly would want to document that and explain, well, why does this not mean that my client's situation has changed such that they no longer have a well-funded fear? Maybe the new regime has the same orientation towards their group.
Yeah.
Which reports are reliable? Are we talking Times reports? I think USCIS does have a page on country statuses. Which are commonly used?
So the Department of State, Human Rights Watch has some, and even some really in-depth reports on different countries. There's also things particular to different claims. There's reports, I think the organization is called 28 Too Many, that does profiles of countries on the practice of female genital mutilation. And there's also several that talk about the different laws across the country on LGBT issues. So depending on the type of claim, there might be sort of global human rights reports. There might be some specific organizations that have done studies on particular topics. And then there might be other just standard media coverage of different issues going on in the countries.
Could you say the name of the one for FGM again? I'm sorry.
28 Too Many.
Thank you.
Yeah. Do you want to offer anything on?
I would add another thing you can do if you're really digging for human rights reports is look into reports that have been submitted to the United Nations. And you can email Sarah and she can put you in touch with me or Jennifer, because we submit these reports to the United Nations and we kind of know where to find them on the UN websites, which are difficult to navigate. But those could be reports from organizations on the ground that work on human rights issues, or they could be international organizations. The Advocate submits those reports there as well. So that's another way to hunt down reports specific to your particular country and possibly on the issue you're looking for.
Yeah, sometimes it's actually UN bodies that are making those reports.
Which one? UN
bodies.
And Amy Bergquist and Jennifer Prestel are our colleagues here who work in our international justice program. So they do a lot of our work on reporting to the United Nations, as well as have done some other work with different groups across the country.
So as someone who is brand new to this, it surprises me that there is not a lot, that no organization has seen fit to say for 80% of the cases, we can fit them into a couple dozen buckets where we've done great research to gather these things and pre-package and continually update the documentation for the objective fear. Is there a repository like that?
Well, there's a couple of things. One, when we transmit a case to the attorneys, we've done some initial research and pulled from some of the, we've got reports on different countries where we have different cases, or like a sample table context. Like Ethiopia has a bunch of different types of claims that you can pull from that have, especially some of those reports that last longer because it's not a brief media article. There's also the University of California Hastings Center for Gender and Refugee Studies. They have a brief bank, and so cases involving gender, they package up precisely that and have some country conditions recommendations on experts. There's a couple of databases that are both based in the UK but have databases of experts, of people that have different expertise on different countries that is searchable. And then the Executive Office for Immigration Review, a couple of years ago, they created a site that has on different countries kind of breakdowns of some of the resources that they suggest they would consider reliable, I suppose, that have some other leads on, both governmental, non-governmental organizations and some other resources that they are there as tools, both for people representing themselves and attorneys that might be taking cases.
And so just to add, the Canada Immigrant and Refugee Tribunal is one source that the Center for Gender and Refugee Studies cites a lot, and they have another document package, just a place where you can go where there's like 12 reports you can see just by clicking on your country. And we create a 2-page document that we give to pro bono attorneys that lays out neatly all of these links And so if you're wondering, how am I going to remember all of this and then find it later, that's how. We'll just neatly hand it to you to have as a starting point. And if you're having trouble finding country conditions documentation, we're always available to give additional suggestions for particular countries of origin.
All right. So the next thing that we'll talk about, and is really another essential element of the claim, is establishing that the government of the country where your client is from cannot or will not protect them. And these fall into two categories. One, if it's the government that's actually persecuting them, then it's pretty clear that they're not going to protect them. So a lot of these are typical political opinion claims where the government is actively detaining and torturing political dissidents. It's going to be pretty clear that the government is the persecutor. In other cases, it might be a non-governmental actor. So we see this in domestic violence cases involving female genital mutilation, where it's cultural relatives that might be conducting the practice. And for LGBT cases, it could be in both categories. It could be that the government is actively persecuting individuals, or it might be family members or vigilantes that are carrying out persecutory acts against clients. So in order to establish, for those that involve a non-government persecutor, you need to show that you either requested help and refused, that you made a police report, no one showed up, or the police said, we're not even going to write this down, it's a family issue, or we don't protect people like you, and turn people away. But it might also be that they didn't, or that there was inadequate enforcement, that they made an attempt but then were turned away at some other level of prosecution, or someone was arrested but then was released the next day, and there were no consequences. Or that there's also inadequate laws or policies, and it would just be futile for the person to seek protection. We might see this a lot in domestic violence cases where they know that they wouldn't be protected because it's considered a family matter, or in some of the other LGBT cases where it's dangerous for someone to report any abuses that they may have suffered. So that's a requirement of showing either the government's persecuted you, or you asked for help and you were refused, or it would be really futile for you to do so. Yeah.
I'll just add that in some countries, there's an intersection between what the law is and what non-government persecutors do. So the law may be a pretext for vigilante groups to do things. So in Cameroon, for example, they prohibit same-sex relationships, and you have these vigilante groups that will go and beat up people because they think that they have violated the law or are going to violate the law. In Russia, you have the prohibition against propaganda against children, and so you'll have people spying on who goes in and out of a gay bar to see if any of them are teachers, and then they'll report them to their school to get them fired. So this is all private actors who are doing it, but it's on the pretext of there's this law that prohibits this action, and so we are going to help out the government in that regard. So I guess in that case, they wouldn't need to turn to the government to say, can you stop this person from getting fired, because the law justifies it, sort of opens the door to that vigilante action.
Right, and that's where the country reports and that other information showing, this is how it's handled in my country, and this justifies not seeking out protection can be really important. So turning back to the cases, and let's look at that Mr. S. and which category does his claim fall into in terms of persecutor.
His membership to a social group, LGBT community, and actors appear to be the government, the police in particular, as an arm of government. In terms of fear, it seems to be both credible and real, since it resulted in beatings and rape. And as a member once said before, there's no end to this because it's a permanent identity.
And I think we'll loop back on this one when we talk about nexus too, because it appears that he was beaten after he reported the election fraud, but it also included homophobic insults as they were harming him. So Allison will talk about a little bit later, talk about how that factors in when you're looking at cases where there might be multiple reasons going on in terms of people being targeted.
So political dissidents would be part of this then too, with the reporting of the fraud.
Yeah, so he could potentially have a couple claims in there, both based on his actions related to the election fraud as well as his sexual identity. Okay. So if someone does have a claim of past persecution, and I would say in most of the cases we work with, there's at least a solid claim of persecution. We're going to make both arguments that there was past persecution, and even if there wasn't a finding of past persecution, they have a future fear. And the past persecution labyrinth, I'll call it, is a fascinating one, particularly when we're looking at what are considered humanitarian asylum claims. So a typical claim, if you establish that you've been persecuted in the past, there's a rebuttable presumption that you will be harmed in the future. And then the burden shifts to the government at that point to show that there's either changed circumstances that make you no longer in danger of persecution, or it's reasonable for you to relocate to another part of the country. And that's more than whether the persecutor can find you. It's looking at other things about, will you be able to find employment? Is there a support system that you can go somewhere else safely in your particular country? So we're considering the size of the country. Are there different laws related to the status you might have there if you were born in another part of the country? Are there other tribal or subdivisions in the country that might make it difficult for you with all of your identity to be able to safely relocate somewhere else? And changed circumstances could be a change in the country, some change in the regime, or some change in the law that was there, or something that happened in your life that makes it no longer dangerous for you to return. Maybe you were harmed as a child and now you're an adult, and that might factor into whether or not you would be persecuted in the future. If the government does present, or the facts present an argument that there is a rebuttable presumption, you can still be granted asylum, which is considered humanitarian asylum, if you can establish that the harm that you suffered in the past was so severe that you shouldn't be required to go back to the country at all, or that you'd suffer some other serious harm. And this is particularly relevant in some of the cases where we see harm that individuals face that constituted persecution when they were a child. One of the cases from a couple of years ago involved a grown 30-something woman from Guatemala that was from an indigenous group, and as an infant, her and her family were affected by the civil war in Guatemala and targeted because they were indigenous. Fast forward 30 years later, she's being extorted by gangs who are threatening her if she doesn't pay them money. Now, that claim itself will be a really hard one to win, but she was granted asylum based on that harm she suffered as a child and the real life-threatening reality that she might be killed by the gangs, even though it doesn't satisfy an actual independent claim for asylum. So those are some of the things to think about, particularly when there's incidents of harm that happened in the past. The other cases are when you're looking at future persecution and needing to establish all of the elements and show that you have a fear either based on something that puts you into a group that might be targeted or some real life experience. Yeah.
Like in the example you were giving, there didn't have to be a link between her persecution and her family and the current
and the other
danger.
serious harm. There does not. Yeah.
It just has to it just has to be life threat.
Yes, it just has to be severe enough, the harm that they suffer. Yep. And so for future persecution, this might be typically if it's an LGBT case, maybe it's someone who came to the United States and then came out and identified as gay or lesbian, and now they have a fear of going back. And maybe it's because of the situation in the country, or it's because they shared it with their family members or others that are now specifically threatening them if they do return on that basis. And so it would be the burden of the applicant to establish all of all of those elements in order to establish that they have a well-founded fear. Okay, give it back to Allison.
All right. So we were talking a lot about protected grounds, and we've even looked at some of the protected grounds potentially applicable to our case examples here. But so one thing that really limits eligibility for asylum, lots of folks who flee to the United States might see suffering very serious situations in their home country, potentially due to civil strife. But asylum is only available to individuals who can show that the harm they suffered is on account of one or more of these protected grounds. So the grounds, of course, are race, religion, nationality, political opinion, and particular social group. So it's important when you're thinking about race. Like Sarah said, we had a successful claim based on someone's indigenous heritage. So that's a claim that could be both on account of race and nationality. So race can be part of a group within a larger society that's harmed, like Palestinian or other stateless individuals. Religion could be religious belief or lack of religious belief, or even imputed religious belief could be a protected reason. You just have to look at the persecutor's actions and statements and the timing to see, okay, why are they harming this person? Political opinion also could be either actual or imputed. We see a lot of situations where a political opinion is imputed to a family member, even if they aren't themselves political, because of what their other family members are doing. So that could still be a reason for protection. So particular social group obviously is the one that we might wonder, well, what is that? I know those other words. Particular social group is just like the other. It was created in contemplation that the way that people harm one another evolves over time. So the drafters of this law wisely thought, well, we want to make sure that when someone is targeted based on inherent characteristic, we have a way to offer that individual protection. They can show that that inherent characteristic was the reason they're targeted. So particular social group, we'll talk about the case law in a moment, but that individuals have to show that it was some inherent characteristic that they cannot change or shouldn't be required to change that was the reason they were targeted. And the connection between the protected ground and the harm, the individual has to show under the law that it was at least one central reason. So it can't be a peripheral reason that they were harmed, but it also doesn't have to be the only reason. If there's some personal dislike between the persecutor and the individual harmed, then they could still have that personal motive and then also have this protected characteristic as a motive. Or particularly in some of our Central American cases, we might see that children are targeted by gangs because they want to recruit them. But in some cases, children are also targeted based on a protected characteristic, like their religion or a political opinion that they may have voiced. And so we can still make out a claim for protection for them by showing that there were mixed motives and that one of the motives was the protected ground. And so going back to Mr. S's case, so we talked about how he was targeted based on, it appears based on his sexual orientation, right? Because the police, the manner in which the police harmed him, the homophobic insults they made to him while they were attacking him. But he also was targeted immediately after reporting election fraud, so based on his political activism. So in that case, there's more than one protected ground relevant to his claim for asylum, and he only has to be granted asylum based on any one of those protected grounds. So the adjudicator only has to agree with you on one of your arguments, and of course you'll make all the arguments available for your clients.
Allison?
Yeah.
So for our client, he's a member of a persecuted ethnic group, but the reason he's specifically targeted is because he's politically active, representing that group. So in that case, you consider it the political opinion rather than the ethnicity, or
You would present both claims. So for Ethiopia specifically, there's a lot of good evidence that the Oromo ethnic group is targeted for harm by the government. And that individuals who aren't political are targeted and tortured, detained, even if they're not politically active. But also that political dissidents are particularly targeted by the government. So you would present both protected grounds, and you'd establish in your evidence the existence of both protected grounds and the connection between those and the harm that the applicant suffered.
Can imputed characteristics be a part of every one of the previous groups?
Yeah,
Okay.
they can. Yep.
So all you have to show is that somebody else believes that of you, not that you actually identify as any one of those
Exactly.
qualities. Okay.
Yeah, the persecutor. For example, if there's someone who is perceived as gay, even if they don't have that orientation themselves, then and they're harmed as a result, then they can present a claim as long as they can show that the persecutor believed them to be gay and therefore harmed them. Yeah.
And related to that, it could be, I don't want to say derivative, but a family member. Like if they have a parent who's gay and they're a child and they face persecution because of their parent, that's okay to rely on it in that way as well.
Yeah, exactly. So family membership is one of the earliest recognized particular social groups. So if you are targeted based on, and actually in this like seminal asylum case on particular social group, it specifically listed family relationship as a protected social group. So there's been some interesting case law since, but we will help you to advocate on those cases. Yeah.
When you're like pleading or making claims and are multiple ones of these, the multiple grounds, is the judge going to have to find that one of those individually stands on their own, or can the judge kind of say, find based on both of them?
Yeah, the judge can agree with you on every argument you make and then grant the person based on persecution on all those protected grounds, or the judge might not agree with you on one argument and might agree with you on the other protected ground. So they only have to find that persecution occurred on account of one protected ground in order to grant your client asylum. And so anything that seems that it was a reason for what happened, that you believe it was the central reason, you would present the information. So you'd present those homophobic insults. You wouldn't leave that out of the facts as you present them. And you'd present the information about election fraud so that the judge can, if they find it was only based on political opinion, I mean, you would disagree with that outcome, but you would, be fine with your client getting asylum that way.
Yeah, I'm kind of just wondering if it works kind of in an intersectional way. I can't really think of an example, but if it's like, if one of them on their own wouldn't be enough, if any of it.
Cumulative?
Yeah. Oh, yeah. Well, I guess you said
Yeah, that's a good question. That if there is some reason that's not related to one of the protected grounds, then it might dilute that argument that it was one central reason. Like, were you targeted because you had this identity, or did they really just want your money, or were they really just committing a crime? And so, in that regard, it can make it a little difficult. And thinking through, do we really want to present 20 claims, or are we going to really narrow down the ones that we think we have as strong? But it doesn't have to be like all adds up to 100%, and there's a slice of the pie. It can be mixed motives, as it's called. Yeah.
Exactly. So if at first you think there might be 6 different protected grounds, then you might not present all 6 because the judge might say, well, none of these are one central reason. You're saying these are all potential reasons. You would present the ones that you think are strongest.
But the key of the language is it's one central reason, not the central reason, is what gives you the flexibility to make a mixed motive argument.
Okay. And there might be a case, for example, where someone's expressed a feminist political opinion and is also a victim of domestic violence. So both her her political resistance and her status in a relationship she can't leave might be relevant to her eligibility. Yeah.
Can you talk about framing the particular social group to try to lump in a bunch of things like gay people who oppose election corruption or something like that? Is that advisable, or is it best to keep those separate?
I think it's really a case-by-case determination. And so when we give you, when we transmit a case to you, we'll have a proposed particular social group or a few proposed particular social group that based on the case law will suggest making. So in the case of LGBTQ individuals, for example, there is a published Board of Immigration Appeals case saying that gay men from Cuba is a protected group. And a lot of case law has come out since then saying gay individuals from all over the world are a protected social group. So in that case, you wouldn't necessarily have to say it's a gay person who has opposed election fraud. And, in order for the courts to recognize that person as validly in need of protection. But, for example, for survivors of domestic violence, you would have to, the protected social group that has been identified as valid by the board is married women from Guatemala who are unable to leave a relationship. So it's not just married women anywhere in the world, it's married women who can show, and it's been extended to women in other kinds of domestic relationships, who can show that based on the country conditions in their country of origin, if they try to leave the relationship, they won't be supported by society. They won't be supported by law enforcement. That there's an idea about the role of women, there's an idea about the family relationships that will prevent them from getting support.
Do these opinions have controlling authority? I'm not familiar with these courts. Are these appellate level decisions?
Yeah.
Or?
Yeah, so we'll go over the appellate structure. But the Board of Immigration Appeals is the appeals court still within the Department of Homeland Security that controls both the asylum office and the immigration courts. And then our circuit here, the 8th Circuit, will also issue decisions on asylum. And so the Board of Immigration Appeals, their published case law, and then the 8th Circuit's published cases are controlling on our asylum officers and our courts. We also will bring in persuasive authority. So the UNHCR has published a lot of guidance that is persuasive, and then we also have lists of unpublished cases from the BIA that give us a good sense of where they're going on an issue. So of course the adjudicator wants to know, well, am I going to be overturned on this, if it's appealed? If you can present those unpublished cases, that's helpful to have for the adjudicator as well. Any other thoughts on that? Okay.
Can I ask one more question
Yeah,
about that?
please.
Sorry. So is there any reason that you'd want to fully develop the case in the sense of course, you have to do the weighing balance of how many issues do I present so that I can still get the central argument around one particular persecution identity. But can anything happen in between the time that someone's granted the asylum and like 5 years later or so when you can apply for citizenship, such that like if a country condition changes and on the record you've got one issue that's still solid and another issue that's not? I mean, I guess the question is, can anything happen after you're granted asylum such that you want the record more fully fleshed out about all of the persecuted issues?
Well, so that's really interesting. There was just a case that came out from the Board of Immigration Appeals that says you have to present your protected grounds before the asylum officer and then the immigration judge. So if there's something that happens that changes during the time that you're presenting your case as an initial matter, then of course you can present the new information there. But you can't add a protected ground when you're at the appellate level. However, you could make an argument that you're applying for asylum anew based on a changed circumstance. If you have a new reason. So you typically, if you've been denied asylum, can't apply again. But one exception is that if there's changed circumstances that make you now eligible for asylum for a different reason, then you can apply again. So.
Well, and I think maybe to the question of that there's a change such that the claim that you won on is no longer winnable and they're going to take your asylum status away.
Oh, okay.
At this point, we haven't seen them really actively trying to do that. But it is something to keep in mind in terms of when you're laying out the claims. However, but as Allison mentioned, you would have an opportunity to reopen or revisit and see, well, maybe that particular claim is no longer relevant, but I still have a fear to go back because of these other.
But it's not like TPS where you've seen any issues with that, where you've gotten the status before citizenship and something's happened in between in the country.
Yeah, and it's not that common, and there's a whole other process if they're going to try to terminate the asylum or asylum status. Yep.
So going on to talk a little bit, so particular social group is one of our areas of asylum law where we do have a lot of case law. And if you're thinking, well, how am I going to research all this case law? This sounds overwhelming. We have all kinds of different practice advisories on case law for particular claims and lists of case law and their holdings. So we have a lot of really good places for you to start when you're taking on a case. That will make it much more manageable for you to know the controlling law on your issue. But so the definition of particular social group was initially laid out in Matter of Acosta in 1985, and this is still the most important aspect of particular social group definition. That there must be some common immutable characteristic that is fundamental to the individual identities of the group. So the one that we already discussed is gay men from Cuba. The individuals can show, well, I'm from Cuba. That's not something I can change. I can't change what country I was born in. I can't change that I was born biologically male. And I can't change my orientation. And that's not something that I should be expected to try to change. I mean, that's another biological reality. And so that was recognized as a group of individuals who have immutable characteristics. And so later on, in the late 2000s, there were some additional aspects added to the particular social group definition that now we always have to keep in mind as we're advocating on behalf of our clients. The individuals have to show that they're socially distinct. So this doesn't mean that you have to be able to determine that they're in a particular social group as soon as you look at them, right? It's not a visual requirement, but you have to show that there's a perception within society. So society's perception, rather than the persecutor, is the essential facts to look at here that show that this group is perceived as somehow distinct. So in the example of the group of gay men from Cuba, the case where the man was granted asylum based on that identity, he could show that he was repeatedly demanded to come in and report to the government, purportedly for health exams, but then he was forced to answer questions about his relationships and take certain medical exams that he didn't want to take, and that he was repeatedly beaten by individuals within Cuba who identified him as gay or perceived him to be gay. So he could show that he was seen as distinct not only by the government, but also that he was seen as distinct by individuals within society. So another thing that you can look at is, are there laws pertaining to this group? Are there advocacy organizations pertaining to this group? You know, even if the person doesn't have this group doesn't have effective protection, what are other evidences there that society sees this group as a group? So are there like social organizations? And then particularity is another aspect of the particular social group definition. So it has to be sufficiently precise, discrete, and with definable boundaries that through a limited inquiry, the adjudicator can determine if someone falls inside or outside of the group. So with the group of gay men from Cuba, it's with the affidavit and the testimony, the judge can determine if this individual is actually within that group or not. If they find him to be a gay man born in Cuba, then they can tell, okay, he's within the group. It can be more complicated in, for example, a domestic violence type of situation where someone has to show, based on the record, that she could not leave her relationship in her particular country of origin. But the courts have found that there is a limited inquiry they can do based on the record presented by the applicant that shows whether or not someone qualifies as a member of that group. And so groups that have been found to be too vague are, this is a youth from El Salvador, for example. Many advocates have tried to advocate on behalf of youth in Central America who face life-threatening situations because gangs are trying to recruit them. And they've been again and again denied based on the particular social group definitions presented, saying youth in Central America is too vague, or in El Salvador, because what's a youth? But if advocates try to say, well, youth between 15 and 23, for example, that's what country conditions evidence show us are the group that's primarily targeted, then they've been denied by saying that that's not a socially distinct group. There's no evidence that people perceive individuals who are between 15 and 23 is all that different. So these additional aspects of the particular social group definition can be challenging for advocates to overcome, but of course we have a lot of resources to help you do so. So it cannot be defined by the harm suffered. So you can't say, for example, a domestic violence victim or survivor of torture. You have to show an individual, a separate characteristic that shows that somebody was harmed. And then again, there's a lot of circuit law and BIA decisions that will help you to access finding different groups to be protected groups. And again, multiple particular social group definitions are just fine. So if there's a few different groups, for example, in the context of survivors of sexual and gender-based violence by gangs, one might be able to show that they're in a relationship they can't leave, a domestic relationship, but also that they were targeted and treated as property by a gang. So based on a way that women are often targeted uniquely based on their gender by criminal gangs. And it's really important to distinguish the actual group from the nexus. So establish the existence of the particular social group, establish that your client is a member, and then separately show that the harm occurred on account of the protected group. So this is the group that we were talking about. So basically all of these different aspects are things that you'll have to show through birth certificates, through the applicant's affidavit, that they do fall into the particular social group you're advancing. And so sometimes that might be telling the history of their life. How did they come out as gay, for example? What was their first relationship they were in? What did they experience as children from society as a result? And of course, there might be other grounds that are relevant to the applicant's claim. For example, if the applicant is out in their home country and it's an oppressive place for an LGBT individual to be open about their sexuality, maybe they're involved in an advocacy group that is advocating for better protection for the rights of LGBTQ individuals. And maybe they're openly living with a partner despite knowing that they will be oppressed as a result. So that could be a political opinion or imputed political opinion could be a separate ground for protection depending on the facts of the particular case. So in this example, Miss N is a part of the group Wanda Geya, right, which is an advocacy group for LGBT rights. And that group was attacked by a mob. So you can show that her political activism is a separate ground for protection. So the on account of. So this can be very hard to show, right? Because no persecutor is going to hand your applicant a note saying, I harmed you because of this protected ground. So it can often be difficult to show why somebody was targeted. But what you'll use is typically circumstantial evidence. So you'll look at the statements that were made to the applicant by the persecutors. And this is why it's so important for your affidavits to be really specific and really to dig into, well, what did they say to you? Where did the persecution happen? Were you targeted every time that you left the church, right outside of your church, in a religious claim, for example? And also to look at patterns within society. Are gay individuals targeted in a certain way? Like in Uganda, we see reports of people having tires put around their neck and then the tires being burned. So if this individual suffered that same type of harm, then there's a suggestion that it might have been on account of that protected ground that you're meaning to advance. Okay. So here, looking at Miss N's claim, we have different evidence that we would present to show the connection between her protected ground and the harm. So her father disowned her, right? So clearly he disowned her because he learned that she continued to be a lesbian. And so that's helpful in showing that his persecution clearly happened because of her sexual orientation. And then we also pulled some quotes from the 2016 Human Rights Report for Uganda, showing that the United States Department of State recognizes that LGBTI persons face discrimination, legal restrictions, societal harassment, violence, and intimidation. And one social norm that same report highlights is that the LGBT community had to cancel a pride parade in the year that the Department of State was reporting because the ministry, just like Amy was talking about, didn't use the law to mobilize angry mobs to attack the pride parade. So those specific examples can be really helpful in showing these more general statements to be true. Okay. Sorry. Sarah's going to jump back in.
Yeah, so I think we'll go through there have been awesome questions. But we're going to go through the alternative forms of relief, and then we'll take a break and finish those and then work on some of the other materials that we brought to work through things in a little more, work with some of our examples and some of the other resources we have. So this is going back to something I talked about earlier in terms of the government protection and that element and saying, okay, you've been harmed, but did you get help, or who was it that was behind the persecution? So when you're thinking of cases where it's a non-government actor, did you seek protection? Were there calls to the police? Were they responded to? If there is some sort of effort that you have documented, do you have it? There was a client we worked with once who had made a police report, and we sort of weighed how dangerous is it to try to reach out to get it. We knew it existed and had made repeated attempts to try to right to the police office in order to get it, and they never sent it, but we did have that documentation of showing the efforts, or if there's a family member that's going to try to get the evidence. And we'll talk a little later about just the importance of corroboration, but always working with your clients to balance how important is that piece of information. Is it going to put anyone in harm that the client doesn't want to be harmed, and how, just sort of weighing the pros and cons. Because if it is not reasonable to obtain the information, that then becomes part of the affidavit, and say, I know this document exists, but it's dangerous for my family to get it, or we aren't able to get it because of X, Y, and Z, and providing that explanation.
Applying that element to Ms. Ann's advocacy, would it be just that, I don't think she contacted the police, but would it be that it's just not reasonable to contact the police and expect them to assist her?
Yeah, because LGBTQ, living as an openly gay person is outlawed under the law in Uganda.
Okay.
So I think there's good evidence there that it would not be reasonable for her to contact the police, and say are more likely to detain her than to move her.
Where the law doesn't speak to it, but there's just a general sense of intolerance. Can you just say it's not feasible to do this?
Well, and then in those cases, trying to find those other reports that explain, there might be other human rights reports that say, people don't make reports to the police because they know that it wouldn't be helpful and result in protection and may result in harm. So finding those other pieces that help support the claim. It's probably not going to be enough just for the client to say, yeah, it would be futile. Having some other objective evidence, or even statements from other people they know, supporting that reasoning.
I don't think there is a law in Russia outlawing homosexuality. However, there have been a spate of anti-gay, LGBT, QI violence, but could you apply that same sentiment that there's no law out there? However, look at all these cases in which society has been very hurtful.
Yes. So yeah, if there isn't a law on the books either to protect or to prosecute individuals, certainly all of the other, like the law is silent on the issue, but this is actually what's happening in the community, and people aren't being protected. Vigilantes aren't able to act with impunity with these actions. So these are a couple of layers in terms of looking at, first, are there laws that exist on the books that outlaw homosexuality, or that offer protection to LGBT folks that would lay the claim that there's specific harm by the government, or that there's protection. And then on the one hand, if there's laws prosecuting people, are they being utilized? Are they actually harming people in their implementation? Or are there laws that are supposed to protect individuals that are being harmed by non-government actors that are actually not being utilized to protect them? And then looking at both statistics on either end, and then what other resources exist for people that are being targeted. Is there somewhere else they can go for safety within the community? And is it reasonable? Is it reasonable to expect them to have to hide in a community center in order to be safe in the country? Or is that not a reasonable expectation of that as their only resort that they have? In terms of, it kind of works both in the government protection and in the relocation. So just turning back to that factor, again, we're looking at the specific country, so it's very different if you're talking about Djibouti versus Russia in terms of where you can relocate. And if it is a government actor, it's presumed that you're not going to be able to relocate because the government is everywhere. So it's really looking at the size issues is more important when you're looking at non-government actors. And again, it's more than can the persecutor find you. Certainly that's going to be one of the factors, but what other is there some sort of civil strife that's going on in the country that they're not able to be safe somewhere else? Do they have connections with family? Are they going to be able to find a job? If it's an elderly woman in a country where it's expected that both elderly and females are provided for by others in society, or by males, and her persecutor is her husband, then it's going to be difficult for her to be able to relocate safely. Yeah.
For the relocation, speaking specifically about LGBT clients, they're not expected to relocate and then be closeted, right? I mean,
Right.
that's not a requirement. So
Right, right. And so talking to the client about, well, is there somewhere you could be safe? And they say, well, I could be safe if I completely hide my identity or if I'm physically hiding out somewhere. That's not considered to be reasonable. They should be reasonably relocating to somewhere and be able to live out their identity as they may. A couple other considerations. Some we've touched on, others we have not. Going back to what we talked about the beginning and the one-year filing deadline, it has to be. It has to be filed within the year of the last entry. It might be that they came to the U.S. 5 years ago, and then they returned within the last year. The trigger date is the most recent entry. It will certainly become relevant. There might be discussions about, well, what was this other trip and how it may factor into the claim, but the filing deadline question is going to be the most recent entry. A couple of areas that are evolving in terms of the exceptions to the rule. There might be an exceptional circumstance of something that happened during that year that prevented someone from filing. So, if there were medical issues or if you were a minor, you're considered not to be legally competent to know that you needed to file within the year, or there's some other mental health issues that were going on during that year. That might create an exception. Or is there a changed circumstance that makes it such that you were not, you wouldn't have been persecuted within that year, but afterwards something changed that made you fearful to go back. So, if people have been here for several years and then came out and all of a sudden their family knows and they're getting threats and it's dangerous for them to go back, that might be an exception. There's also an exception if you're maintaining legal status. So people that come in as students, as long as they're maintaining and are in student status, they'll have an exception and can file within that time or have to file within a reasonable period after their student status ends. We talked about this before, the humanitarian asylum, so looking at was it particularly severe because of the age of the individual at the time they were harmed, or because of what the harm was? Is it so egregious they shouldn't be forced to go back? Or is there some other serious harm? And there was a good case several years ago now that included in that other serious harm if there's psychological harm, or looking at what the person suffered has caused an ongoing mental health issue for them, and they can't get the care they need in the home country. That's also relevant in terms of other serious harm or other psychological harm they'd have just being exposed to the place or being near the individuals that in the environment where they suffer the persecution. And then one of the other things that we try to screen for when we meet with clients, but things might change or things might come up throughout the representation, is other types of immigration relief that might be available. Allison will talk about the withholding of removal and Convention Against Torture, which are when you file a claim for asylum, the application is considered both for asylum, withholding of removal, and Convention Against Torture. And Allison will talk about those three different categories. Also, there are immigration relief for individuals who are victims of serious crimes in the form of a U visa, and that may happen while the person is living here in the country. We've had clients that we're working with that they come in and say, well, I was a victim of a crime, and that might create another form of relief for them. And then T visas are for victims of human trafficking, which is also a lot of our clients are vulnerable to be trafficked either through sex trafficking or labor trafficking. Sometimes in the housing situations they're in, they're told, well, you can't work and you can't pay for rent, but you are going to take care of my kids if you're going to stay here. So creating those environments where people may be susceptible to human trafficking. And then I put up prosecutorial discretion, but that's not quite as common anymore. Though on that note, I will say that it's a bit in flux, but certainly we're in a time where we're asking if particularly the cases before the court, seeing if the government will stipulate to a grant of asylum. And we've seen success in cases involving past female genital mutilation. And at one time, they were stipulating to specifically for LGBT cases from Cameroon. But I think the latest is they said they'll only stipulate to cases involving transgender individuals. But they haven't really told us why they're diverging. But it never hurts to ask and find out what the position is of the government, or if they'll stipulate to will you stipulate to the fact that they were persecuted, so you can avoid the client having to retell the entire persecution when they're on the stand.
And sometimes they'll even stipulate after the testimony. I mean, we had a situation recently where the testimony of the psychologist was so compelling that the government attorney approached the pro bono attorney and said, we won't appeal. You know, if there's a grant of asylum by the judge, you know, maybe we should let the judge know that we won't appeal this decision. And so they let the judge know that, and the judge ultimately ended up granting that day.
Yeah. So a couple of things in terms of going back to one of the questions at the beginning about the benefits when you receive asylum. One is you can file for family members, which for asylum claims that includes your legal spouse and any children that were under the age of 21 at the time you filed the asylum application. You can petition to have them join you here in the United States. You can travel outside of the United States so long as you have a refugee travel document, though it can jeopardize your claim if you go back to the home country. And then you can apply for permanent resident status after being an asylee for a year. You're eligible for certain public benefits and refugee cash assistance for a time, and then eligible to work without having to renew a work permit every year. Yeah.
Can you explain the situation for LGBT clients who are granted asylum? They don't have the ability to marry their partner in their home country, how that works?
Yeah, well, so the law says for the spousal, the dependent for the spouse, the marriage has to be legal in the country where it occurred. So there are other remedies or other ways once someone is a permanent resident, or then they can become citizens, that they could marry subsequently, or file a fiancé petition to be able to marry in the United States. But I don't think there's an exception in terms of it. You know, it is a really interesting question that we see in some other cases involving cultural adoptions too, where the oppressive government is saying that it isn't recognizing the adoption, but we'll give you asylum, but we won't let you reunite with your family. So it is really good, a good question, but I don't think there's a good answer for it yet. Yeah.
So a little bit more about adopted children, where it's a cultural adoption. How do you approach that?
Yeah, so they've been challenging cases, but there is some recognition of cultural adoptions, but it's usually if there's no other civil legal avenue that someone could have pursued in the country. So it is something that there's at least 2 different countries where we've seen it come up and really be a barrier for families to reunite. But
is there a risk for a client to include those children on an application?
You know, we generally will tell people if you consider them to be your children, put them on there, and then make the clarification that, you know, this is how this child is related, so it's not interpreted as a, you know, fraudulently adding a child that's not yours. You know, saying, well, these are my biological children, these are the ones that I've adopted, and I do or don't have the paperwork to go along with it. But yeah.
What's the earliest point in the process that the spouse or the child is allowed to join the applicant?
So currently it's once they've been granted, you start the process for the petition. That said, if the family members are, you know, if they had a visa and they enter the United States, so long as they're being truthful and honest about where their family member is, and, you know, there's been some cases where the spouse will show up at the airport and say, you know, I'm here on a tourist visa, I'm here to visit my spouse who's going through the asylum process, and they've been allowed to enter. And theoretically, they could be added to the claim at that point. So, you know, it's a little sticky area in terms of what is your actual intent, but at the same time, that's one of the hardest things for people to have to be separated from their families for so long. So Allison's going to talk a little bit about the bars to asylum. We'll take a break, and then we'll work through some of the other. We've got a sample application and affidavits, and then, well, actually, maybe before you do that, I'm just going to jump to. Oh, do we not have it?
While you're doing that, in terms of the application, do you do a lot of the intake work so that we have all the information to prepare the petition?
Yeah, so we have a thorough intake process. Folks will either be referred by community organizations or they'll call us, and then we'll take down that initial information. And if we think there's a possibility that they would have a strong claim, then we'll invite them in for a full interview, and we'll get all the documents the person has at the time they first meet with us, and then we'll deliberate on their case as a full staff. We might ask follow-up questions if we are concerned about any issues, and then we'll also think really carefully, is this a case for a pro bono attorney? Does this person income qualify for us? Or is this someone who should seek a private attorney? And if we think it's a strong case, they income qualify, and it's something that a pro bono attorney could handle with the training that we're giving, then we would go ahead and accept it. And then we would refer to you the case with a detailed description of the country conditions, and then also of the claim as outlined by the applicant. Of course, there probably will be additional facts that will come out when you meet with them, and then all the documents that they provided, in addition to lots of different templates that will help you to handle the case.
And then just to the question about during the asylum process, so individuals are legally allowed to stay in the country. There's no automatic extension of legal status when you file a claim. So if you come in as a tourist, and even if you file before your status expires, you would still fall out of status and be vulnerable to being placed into removal proceedings. After 150 days, you can apply for a work permit, and then it's renewable. They're now issued them over 2 years. It gets a little more complicated if someone's before the immigration court, and maybe now if they're adjudicating the asylum office claims a little more quickly, because actually not for that, because if the judge issues a decision in your case before you hit 180 days of it being pending, then you don't get a work permit, even if you appeal the case. And there are different things that start and stop what's called the asylum clock, depending on what, if you're filing a motion to change venue or you ask for your interview to be rescheduled, that will stop the clock until you actually show up for the interview. So there's games with the numbers that make it really difficult at times for people to be able to support themselves.
How does it work if you're going the affirmative route and then you get referred to a judge?
The clock will still run.
Okay.
Yeah.
Okay.
Yep.
Thanks.
And then the social service referrals are really important. And for many of our clients that come in, they're not able to support themselves. They can't access any public benefits. They're usually couch hopping with different people from the community, and add the layer for LGBT folks who can't rely on their community in many cases. There's a lot of isolation and really need of support. So we have a social work intern that works in our office that helps try to identify referrals, and there's also a asylum support network in the community where we sometimes will pair people to work with community members that are interested in supporting asylum seekers in a similar way that the refugee resettlement agencies work with communities that help folks get resettled here in the U.S. Do you want to talk about it, or should we take a break?
No, we can take a break.
Yeah. Why don't we take about a 5-10 minute break, and then we'll dive back in with a few of the other pieces, and then talk about some of the work through some more samples.
Which way are the restrooms?
Right out there. That way. Go out that door. And do you see the reception desk?
keep walking.
Okay. Thank you.
Oh, yeah.
Yes, please do sign it. Yeah, if you didn't get a chance to sign in at the beginning, please do sign our sign-in sheets so that we have you on record for CLE credit purposes.
Everyone's connected to Teton or the other LGBTQ need this work. Because they're hyper-vigilant about making sure the resources are targeting LGBTQ residents, and so they might be able to solicitation specifically for supporting this sort of key everybody. Okay. Go ahead. Their ED just left.
Oh, okay.
So they have a new one,
But their board is really powerful, and
yeah, they just released a report with United Way on Midwest.
No, I think you were.
Okay, so there's a big movement to change that. And this could be, I think, a viable application.
And is it for legal services?
No, for everything. A lot of sports. A lot of housing. I don't think they're aware of the other one. Stuff like that, but I don't think they know about what you're doing. And so, Key Fund is really small resources, but they're connected to a broader network that if you're on their radar, they will do.
Yeah. Well, and Amy,
Yes, yeah. I think maybe
She went to you and you came to
no,
yeah,
with our
clients,
yeah, that's really serious. Because it is.
Tell her I mean, he didn't express to me that he had he said that
Got some information for our clients because one of the
yeah.
we found that the connection to other LGBT groups isn't there, and they're extra isolated.
I heard you say that they can help make that shift.
Yeah, because we've tried to do some form of commentary.
Yeah.
You know, like if we have two clients from
Yeah.
Doing otherwise, you know, that one family member that's supportive of them is pretty isolated within their
right. So because they're ED less, I don't have the direct connection with the housing program manager.
Oh, yeah.
And it's just like the Arise project in the United Way is also a viable option because they do housing specifically with homeless youth for LGBTQ. So if you have any LGBTQ, and aside from Arise,
what do they do?
Probably, yeah. And I think it's, I don't think they bother to find it. The idea is just that the LGBTQ homeless population in Minnesota is 40% of the population. 40% of homeless youth are LGBTQ. Anyways, if it makes sense for you,
It was like a college.
yeah. So if it makes sense to you, I will link you to Sam, who's my same role, but doing housing, but he is the one who co-wrote that report, and he has a new connection to the fund, so hopefully you guys can get a conversation on it. At least, if nothing else, I
know, right?
Then to be aware of you, I think it's helpful both from the social services lens.
Yeah.
So if there's training that needs to be done on their end to learn from you about how the asylums are not necessarily integrating in a holistic manner to the other supports equity for the other question I had is just like as you're going through the process, so it takes a year before you can apply to be a permanent resident. I mean, how many are denied permanent resident applications?
I don't know. I assume you remember, but I don't know.
It's been a long
Like, what is, I guess, why they're just granted?
That's interesting because there's been because they're granted in they're not
But why is it that, like, so it's both that, like, clarification after hearing
Yeah, I don't know, but I know that we're trying to.
I would say
Because we have a client who's a refugee and ICE is keeping them until they adjust. Follow through with it. So we have a client who's been in there for like 6 months, and they're going to adjust them. They're not going to deport him, but they're
Well, anyways, yeah, it is very detailed.
So I don't know where they're yeah. It's always better than yeah, okay, are they? Yeah. Like the film.
But a lot of areas are empty. What they've done is they've made areas into
Okay.
so they're much more.
Or do you want to stage it later? I don't know.
Yeah,
I mean, maybe we should stage it later.
So there really are offices.
Okay, so
yeah, we're on a single floor in the main building, but it's kind of weird. The building is set out rather large, and then it's kind of in front. And we was in two of those, there are another two, but you never see the people cross that wall because the bathroom, so we are in the same place, but we have lawyers and paralegals and assistants over there.
I feel like the annotated five.
But yeah, we're pretty much on one spot.
Yeah. So maybe if you want to talk about the affidavit. Sure. I mean, if we want to start with that.
John recruited me, so I went there about a year after.
Okay. Yeah. See, that you asked me how long about your, I would assist you.
Yeah, we haven't been quite done yet. He was there before I was. But I mean, we train people. Because they might have been.
Well, I think there's a need. That's a need right now.
Yeah, great. But they don't have it almost all.
No, they don't.
It's like 1,000 tiny cuts, you've got only so much time and sensitive about it, and get accolades or anything like that, then I'll get
How long is it?
I have it here.
Oh, yeah.
Israel, of course.
Yeah, let's ask them. I think
well, I mean, I also come to people that was with,
but you're talking about another.
Yeah, the reason I'm saying it's really
Yeah, but I think that the most time that I was
That's really good question. I don't think
well,
Right. And I don't think we've encountered anyone. I feel like everyone's in the US or
Well, 2 buildings in Hart Spring.
Joint
Yeah,
right
so
around
people
the
find
middle.
it. That's fine.
So that was right in the middle
Wow.
of
Yeah.
so we did a lot of our support and Greg on the workplace side there too. That stuff.
That was the most interesting negotiation I've ever had.
So was it Minnesota interesting or was
No, so here's the basic deal.
Well, that's very cool.
Was that General Mills Bakery was representing.
Yeah. Well,
It's also
and in most people, that would be the evidence. But I've done all of this spin off and a brand in this case, we negotiated that. We signed No. It's not even up outside of March. We'd like it more.
Right.
I mean,
Everybody just like
ultimately, in some ways,
Good. A lot of information. Huh? Oh, well, I started with one big gap. So it's very helpful. What about you?
how was the visit to Sarah?
Yeah.
Which was
I
true.
do a lot of family law.
Yeah.
That's a lot of what I did in Chicago. I had a lot of divorces. Yeah. I moved up about almost 2 years ago. Trying to decide what I want to do.
we could also
So I always worked at nonprofit. So I never, did the private practice route.
Well, I still have to live with it.
Yeah.
Are you on your own or are you with a friend?
Yeah. Literally.
Yeah.
Well, and the foundation.
Yeah. How long? Yeah.
I also wonder.
Yeah.
Do it.
Yeah.
All right, if folks could kind of take your seats, I think we're gonna, in the interest of your time, try to start back up with the presentation.
Right.
There's a lot of red on here.
Yeah.
Okay. Thank you. All right. So we talked a little bit about how important social service referrals are for the asylum seekers you'll be working with, and please do remain in communication with our office as you're looking for therapy or food access or transportation. We have developed a pretty detailed network of referral information. And so for the situation for asylum seekers has become much more challenging in the last year or so, as there's been a lot of policy changes that impact asylum seekers. We've just listed a few here, and this will probably become outdated the second that our conversation is over as policies continue to change. So please do keep in touch with our office so we can update you on any policies that impact your clients. So a few things that have impacted some of the asylum seekers we serve. The travel ban sometimes will, for countries, how many countries is it now? It's like 8. Yeah, so the latest iteration, there's a third version that's being challenged in the courts, but is currently being upheld while it goes through legal challenges, and is applicable to some of our the family members of our asylum seekers, and so that could potentially impact folks who are trying to have their family unite with them here in the U.S. So
I would say, though, that it doesn't create a barrier for people from those countries from receiving asylum.
Right, that's really important.
So that's a good thing.
Yes, yeah, exactly. And so the end of, so temporary protected status is issued to countries where there's it's a discretionary benefit issued by the executive branch, where there's some crisis impacting the entire country. And so previously, several countries that had temporary protected status available based on, for example, like a crisis due to weather conditions, where there's some really severe weather incident that impacts the whole country and really makes it almost impossible for people to go about their daily life, or if there's a really severe situation of civil strife. And so temporary protected status for several countries, including Haiti, Honduras, Nicaragua, and El Salvador, have been impacted within the past year. And so there'll be a lot of folks who maybe have spent decades in the U.S. and will now be facing the end of their legal status and will have to find some other way to stay as they're looking at potentially leaving behind their families and their jobs and their communities. So we may see more asylum seekers who will have one-year deadline issues as they're looking to say, well, I'm really afraid to go back to my home country, but I've been here for 10 years. And then there was a program for Central American minors, recognizing that many minors in El Salvador, Honduras, and Guatemala had valid claims for refugee protection, that where Central American minors were able to apply for refugee status within their home countries instead of making the dangerous journey to the U.S., as many children were doing alone and continue to do alone to seek asylum. It was a small program, but it was recently terminated, and so there are thousands of children who didn't receive refugee status, and some did receive refugee status, of course, but there were lots who received parole instead of refugee status, which allows kids to enter the United States and gives them a work permit, but doesn't give them any legal status. So they're now not able to reapply for parole, that status that allows them to be here legally, and have to look at, is there some other way for me to stay here with my family that was able to bring me here as a parolee? And so we're representing some asylum seekers who are eligible for asylum after their parole has ended and would love to work with you on those cases. Refugee numbers have been significantly reduced at a time where there are more global refugees than ever before. So from the projected 110,000 for this year, it was reduced to actually 45,000. That number has been updated. So, there may be more individuals who are seeking asylum as they're unable to get protection as refugees. And increased detention of asylum seekers has been a major change in our work and in the work of advocates around the country, as not just asylum seekers, but other immigrants have faced detention in vastly increased numbers, and detention is being used as a deterrent to immigrants with valid claims for protection in a much more significant way than the past. And I'll let Sarah kind of address how that impacts our work, because Sarah works with detainees for our office.
So I think a couple of things. We're starting to see a few more people that are in touch with us after they've been detained, attempting to come in through the airport, and then are being questioned about their non-immigrant intent, and then proceed through asylum and are detained throughout. We also, most of the people that are arriving at the border, we would be in touch with them if they are released. So those numbers are down, especially I think because of the deterrent factor. But what we do see happening is and this is actually not new, but it's something that has happened over time, is families being separated. So, for example, we might have a couple that has, you know, a 20-year-old child and a 5-year-old child, and the father is placed in an adult detention facility, and the adult child is placed in another facility, and then the mother and the small child are released. And so kind of figuring out how to either help release someone or help get services for the family member. We had a couple that was separated at the border, and actually the husband who remained in detention was granted before the spouse is set for hearing out in 2019. And so in some cases it may end up in a quicker positive result, but being in detention, particularly if you've been tortured in your home country in a detention facility, is not is never easy. And especially in our jurisdiction here, just seeing the growing numbers of people who are in detention, as we've seen a lot more inadequate medical care or just explicit abuses of detainees, and trying to work with people on addressing those issues as well. And then also other individuals that may not, that they'll have 1-year filing deadline issues. Maybe they don't have a strong exception to the asylum claim, but they do have a strong claim for withholding of removal or Convention Against Torture relief. And so those are other individuals that we might be working with and looking for volunteers.
I have a question. How do you find all these people? You know, do you, because people come in all the time, I'm sure, and people, I mean, I guess if they go to detention, you know where they are, but how do you get the list of people initially?
So for the detainee and anyone who has a hearing before the immigration court, we're on a list of free legal services, so they might reach out to us that way. We also are part of the Minnesota Detention Project and do consultations with individuals at the court before their first hearing, so we might find them that way, or referrals through other agencies or private attorneys. And for the affirmative cases, it's a lot of word of mouth, or people that have friends who've heard of us, or that they're getting services through some community organization that refers them to us for legal services.
So another significant impact on our work is the changes in the processes for both the asylum office and immigration courts. The asylum office recently has several things have changed in the way that interviews have been conducted, which we'll talk with you in more detail in our step-by-step presentation, which hopefully you'll attend at the end of March and early April. But in terms of how the claims are processed, recently the asylum office said that they're going to first interview people who are most recently submitting their applications. So their goal is to have significant numbers about how fast recent claims are being processed by the asylum office, and then they'll later go on and interview folks who have applied earlier. And so some of our asylum applicants who applied 4 years ago, for example, and are still waiting an interview, will now be at the end of the list, whereas people who apply tomorrow will be at the beginning of the list for interviews. And so this significantly changes how we do our work. Previously we might say, well, we know you're going to have 2 or 3 years before you file. Let's get that application filed so that the work permit clock can start running, and you can have a way to support yourself. But now, when you file that initial application, you want to have done a lot of the work to have the claim fully documented, so that when that person's interview happens, you're ready to go. And so some other changes, the court has issued a lot of different policies lately, policy changes, one being that the court will now have quotas on the judges as to how fast they're finishing cases. And there's been a lot of pressure on judges to really quickly wrap up cases. Judges do have a significant backlog, but there's, of course, some due process concerns where you're saying you have to wrap this case up by X date, where that concerns is that limits the judge's independence in making a decision based on what the case needs rather than on their adjudication quotas. There's also been changes in how they're supposed to handle change of venue requests. So oftentimes we were talking about a lot of our asylum seekers will be folks who might be in a different area, for instance, folks who come to the border and then are released locally to our court here in Minnesota. they then have to request that the court case be moved from the court in Texas, for example, that may have handled their claim, to here in Minnesota. Previously, what would typically happen was that the case would then be scheduled for a master calendar or status hearing to allow the judge to deal with evidentiary issues, find out what their claims might be, give them some information about the process. But what the recent memoranda have suggested is that those cases will now be, they're having to schedule them for individual hearings, and the judges who are addressing the change of venue requests are supposed to deal with as many issues as they can before they grant the change of venue. So which will mean that oftentimes folks who are unrepresented will be having to address allegations and charges against them before they're able to change their court case to a local jurisdiction. So if you're taking on a removal case from us, that means you'll really want to be sure to get the record of proceedings so you know what happened potentially in another court before you were able to help start representing your client. Another policy change is towards minors. So children who are, the policy for more than a decade towards unaccompanied minors has been that if they're initially designated as an unaccompanied minor, so a child who comes to the U.S. alone, is under 18 and lacks a parent or guardian to care for them, so they're recognized as particularly vulnerable children, right, if they're coming to the U.S. in that status. So they've been able to retain that status throughout the process of seeking asylum and have been able to then apply to the asylum office to have their claim adjudicated first by an asylum officer instead of, as a child, having to be cross-examined and on a witness stand the first time they're telling their story of persecution they suffered, sometimes child abuse, sexual abuse, in a court. And so one change has been that the courts have been told that they have to, where there's a child before them who has reunited with a parent or a legal guardian or turned 18, strip away that unaccompanied minor status so that the child no longer can apply before the asylum office or take advantage of other protections that are available to unaccompanied children, but will have to apply for the first time before the court. And one other thing that impacts both our clients and then also lots of other individuals who are immigrants or maybe perceived by the police as immigrants is that police officers are being encouraged strongly by the federal government to act as ICE officers. There are a lot of local jurisdictions that have said we don't think it's an appropriate use of our state resources to be enforcing federal law, and it's not in line with our public safety goals to say to the immigrant communities, if you come to us with a public safety issue, we're going to be asking about your immigration status. But however, this is a big change for the folks we work with who now, when they're in an encounter with law enforcement, have to be thinking about whether law enforcement is going to be asking about their legal status. So as a result, we've done a lot of work to educate our clients on their legal rights in encounters with law enforcement, and we have a lot of advisories available if your clients were to encounter law enforcement in their workplace, on the street, or in their homes. They're available in numerous languages, so please do reach out to us for those resources. And also another change is that previous policy in terms of immigration enforcement was a little bit more targeted towards individuals with serious criminal issues or with other particular reasons that they were priorities for ICE. And now the priorities have been changed to all undocumented individuals. So it's much more likely that if your client lives somewhere where there's an immigration raid and they're looking for someone else, and if they're asked about their status as a part of that, they would still be apprehended and then put into removal proceedings. It's important to note that asylum seekers, once the application is filed, have the right to remain in the United States for the course of that adjudication. They could be detained or put in removal proceedings, but it's important to tell your client, you do have the right to stay here and get a decision on your asylum application. And even if they were to be detained, they'd have the right to say, I'm afraid of returning to my country. I want a procedure to evaluate my eligibility for protection. And of course, there's lots of other policies that have been changing that we haven't highlighted here. I don't know, Sarah, if there's others that maybe we should talk about specifically. Okay. But So here are a few ways to protect your client's constitutional rights. One is to advise your client to carry your card at all times. So if they were to have an encounter with law enforcement and they say, I don't want to answer these questions you're asking me, I would like you to speak with my attorney, then they can immediately provide their attorney's information for law enforcement to contact. And we can support you in advocating for your clients in that context. And then also carry a copy of their I-589 receipt on them so they have proof that they have a pending asylum application. And then advise your client that they do have the right to remain silent. In most states, and I think Minnesota, people do have to give their name to law enforcement, their correct legal name, but they don't have to give any further information. And that right exists regardless of their legal status. And to refuse to sign any documents or answer any questions from ICE. And so ICE doesn't have to stop pressuring them to sign documents, but they can continue to assert that right to remain silent. And then if they're in a home raid situation, advise your client that they have the right to refuse to allow ICE to search their home without a signed warrant. So if ICE comes to the door without any documentation, they do not have to open the door. Or if ICE comes to the door with a document with someone else's name on it, they can ask the officer to slip the warrant underneath the door or push it against the window so they can look at the document and say, does this document have the name of someone who actually lives in this house? Is the address correctly completed? Is it signed by a judge or a magistrate? Or is it just signed by an ICE officer? If it's not signed by a judge or a magistrate with the correct legal name of someone who lives in the house, the correct address, they do not have to allow the person to enter. And even if there is a signed warrant that complies with all those requirements, then it's important that they assert that they do not consent to the search when ICE enters their home, because then the search is limited to the scope of the information in the warrant. Yeah.
As a practical matter, is ICE just going to be able to go back and get a warrant and you're just delaying for a day or two or three? Or if you refuse, again, totally in the abstract,
yeah.
But I know what the standard, relatively speaking, would be for ICE to get a warrant for an American citizen. Is it the same for someone who's an asylum seeker, or is it just going to be pro forma that you're just going to upset the ICE people and they're going to come back a day later with the warrant?
Well, they might have to comply with some legal requirements. They can't just go on a fishing expedition, right, if they're going to have to get a warrant. So there might be some restrictions on who they're able to go after. And then also they have to have it signed by a judge or a magistrate. So that delay can be essential for somebody who is trying to ensure that their undocumented family members are protected, right? So if there's someone in the home, let's say, that's visiting them who's undocumented, that they then have that person has time to go and seek protection. Yeah.
What about language barriers? I mean, obviously, not all officers are multilingual. And what if someone is saying, I do not consent, but the officer doesn't understand or lies and says they don't? I mean, it's kind of their word against the officers, right?
Yeah. So we have red cards that we can give out to you that are in English and Spanish. And, but, could be given to clients who speak other languages and just explain what it says in English. Mm-hmm. And they can present that card to the officer explaining, I'm asserting my right to remain silent. I don't consent to answer questions. I don't consent to a search at my home. And they can still say in their own language, I don't consent to the search. And then in an affidavit prepared by an attorney later, that information could be used in a suppression motion if need be.
Good deal.
Yeah.
You can order those red cards in a whole bunch of languages. So on one side, it'll be in that person's language, and on the other side in English, it's like, I do not consent to you searching my home. I do not I refuse, I exercise my right to remain silent under the blah, blah, blah. And then it says, these cards are available to citizens and non-citizens alike, because that's something people ask sometimes too. So then am I indicating am I handing them something that says I don't have status here?
That's a really good point. Thank you. Mm-hmm. Okay. And so important that you tell your client to call you immediately if arrested. So we've heard of some situations where, particularly I think in the situation of folks who have had their children come here, they may have had a parent who is undocumented and had multiple encounters with Department of Homeland Security where they just asked for information that resulted in their child coming into their home and then nothing bad happened to them. So they might receive a call from a Homeland Security investigator or ICE to say, well, just come down to our office, we're just going to ask you a few questions. They might think, oh, this is just like when I answered questions and then my child was given back to me. So they might not think this is something where I have to call my attorney and tell them, hey, ICE wants to ask me questions. So it's really important that you let your client know any encounter with ICE, please call me before you go and respond and get interviewed by ICE without an attorney present. And again, we have Know Your Rights information available in multiple languages, and please take advantage of those resources. Bottom line, please stay in frequent contact as things change so that we can ensure to advise you how to protect your clients. And Sarah, do you want to talk about volunteering?
Yeah, or do you want to go? Let's see. So there's just a couple of slides that go through kind of the typical process when we do work with clients and placing the case of the volunteer attorney. And I think Allison may address this before when we were talking about that. We do a series of interviews with individuals, and then we compile the information we gathered along with any documents that they've provided to us. Usually if it's a court case, we're already trying to get the records even before we transfer the case to you. But this kind of details the process that we take in terms of posting. After this, we'll also send some of the available cases that we have, but we have a monthly newsletter that goes out with trainings. If there's important practice advisories that we're putting out there or available cases, so people that are interested. And then also just talking with us about if there's a particular part of the world or a type of case that you're interested in helping or language abilities. We have some volunteer interpreters and translators available, but really it is on the attorney to figure out, is that a cost you can absorb? Particularly, I would say a couple of years ago, we had a lot of Spanish interpreters that were really available, and now there's so many cases and they're pretty tired that they're a little more reluctant to respond to actually do the interview. Or if you have a language that you speak, for clients, it's awesome to be able to work with someone in their language. We have a number of resources. We have a manual. We have a password protected portal that has some resources. You can always reach out to us for different samples if there's something specific you're looking for. We do have ongoing training. As Allison mentioned, we have a more detailed step-by-step training that's going to take place on 2 different dates in March and April. And then our staff is here, and we often are pairing you with a consulting attorney, or if you're working at a firm trying to identify if there are folks that have experience within the firm. I mentioned the interpreters, and then we'll check in for case updates, and then would like to be informed when the case is complete, or if your case is granted and you're going to help with something else, just to keep us updated on that. And that's just a sample of what's available on probono.net. Okay. Do you want to talk about the athlete?
Sure, please. So we're going to open up for questions in just a few minutes, but we wanted to first get from you, okay, now that you know the basics of asylum, law, and processes, how would you go about representing Ms. N or Mr. S? And we'll go through each individually. What additional information would you want? What documents would you work on gathering? What questions would you want answered in your presentation? So if there's a volunteer who wants to talk about either case, and then we'll share what actually happened at the 8th Circuit with each of these clients. So is there anyone who wants to talk about how they might represent Mr. S or Ms. N? What questions would they try to answer first? What resources might they put together? What evidence might they look for? Yeah.
I'll start. With Ms. N, the basis of the persecution appears to be both political and social group affiliation. So in college, she was a part of Wanda Gea. I would ask if she had any type of brochure or membership materials. Yeah. The mob attacked them. Was there any news coverage of the attack? Any collegiate or in university reference to it, and finally, with hospitalization, if there are any existing traces of it, the injuries or medical records.
Yeah,
effect.
absolutely. Like a forensic medical evaluation that would show any physical impact on the body or psychological evaluation.
Right.
Great. What about Mr. S? What are some things that you might want to find out about his situation? And what might you do in challenging the judge's credibility findings because the judge didn't think, in his subjective opinion, that Mr. S spoke or dressed or exhibited the mannerisms of a homosexual? How would you challenge, what would you present to show the judge that that was not an appropriate way to assess his credibility? Yeah.
It doesn't actually have to be part of a group as long as the persecution is based on the perception that he is. So in this case, regardless of what he identifies with, the government was identifying him that way, treating him as though he was part of that group, and pursuing him and persecuting him as a result of that.
Yeah, so that's one really important thing. It could have been imputed to him. He doesn't have to show that he was actually a gay man. But in this case, he is actually a gay man. And so what else might you say to the judge to challenge the judge's subjective sense that there's a certain way that a homosexual man presents that is the only way that one can present as gay?
Two springboards. One is what constitutes a mannerism or a speaking type. It may very well be that you could identify with this group but have multiple mannerisms. Or it could be that if the stereotypical affectations associated with homosexuality may very well be a death knell for them in that country. And if you can get evidence showing that, and people assimilate or people speak in affected or behave in affected manners in order to avoid the imputation. That might be a good way to do it.
Yeah, exactly. So the facts show that he was afraid to be openly gay. He had not disclosed his orientation to his family. He wasn't a member of any advocacy groups. So, and perhaps his particular presentation was not what the judge's stereotype fit. So actually, positively, the Eighth Circuit recognized that this was a really inappropriate decision by the immigration judge, and when they remanded the case to be reconsidered, they specifically said that a different immigration judge would have to review the individual's eligibility for asylum. And Miss N did ultimately end up being granted as well. She was before the Eighth Circuit. So this was one of the earlier cases where individuals were still arguing that their sexual orientation or gender identity was a protected ground. So this was when the Eighth Circuit kind of finally was coming around to recognize, okay, this is what our sister circuits are saying. We will also recognize these protected grounds. And so we have one more kind of process of applying document that we want to talk with you a little bit about. Please take a look. We have our annotated I-589, and so that's really great to have by you as you're filling out the I-589 form. You'll have to go on USCIS's website to get an updated version of the form, and we can always help you get to that website if you're having any challenges navigating. But have this next to you as you're going through the form because every box matters. So every single answer that your client gives will have a direct impact on some aspect of their eligibility. So you'll see there's some, tiny little boxes like that one right at the top that says check if you want to apply for withholding of removal under the Convention Against Torture. And if you don't check that tiny little box, you could be giving up a claim for your client. So this is a really helpful form because it just kind of points out why is this question being asked? What I want to make sure to include to really show my client's full eligibility for relief. And so another aspect of putting together your client's application that's really important is their declaration. you'll see that the boxes here where your client can say, this is why I fear returning to my home country, are really tiny. So they'll just really only be able to give a summary of their eligibility for asylum in this application. They can to some extent spill out onto the supplement pages if the information doesn't fit in the boxes. But your declaration will be where you'll tell how did the client develop their protected grounds? How did they become politicized? How did they start caring about an issue? How did they start to get active in their community? How did they realize they were gay? How did they end up in a relationship where they were unable to leave? And then what was the persecution they suffered? And you'll be detailed in describing the persecution because you really want to show the adjudicator this isn't just someone who's making this up. They can tell in detail incidents that are unique to their own life. And we'll talk about asking them to include the last and the first and the worst incidents of persecution they suffered, in addition to kind of talking about the general trend of persecution, if it was more of a systemic situation. And so we have an affidavit that we'll send you. Just in the interest of time, I think we're not going to put it up right now, but it's a sample from an organization, Immigration Equality, which is specifically focuses on LGBT immigration issues. And so it's a great resource for you as you go through representing particularly LGBTQ asylum seekers. They have a manual on asylum that's specifically directed towards those types of claims. And of course, you can consult our asylum manual, which is available on our website. But the affidavit is for a gay man who discovered after 4 years living in the United States that he was also HIV positive. And so his argument for a 1-year filing exception is that he discovered that HIV status and knew that for individuals from Brazil who are gay, they receive a lot more of persecution as perceived spreaders of HIV and AIDS. And so he's using that information to argue for a 1-year deadline exception. So a few practice pointers that the affidavit, as you look at it when you receive our samples, outlines, is that it's really helpful to begin the declaration with a brief introduction that lays out the basis of the asylum claim. So you'll give that basic biographic information, and then you'll give the summary. So as the asylum officer is walking through it, they know, okay, this is why this person is applying for asylum. And then issues like the 1-year deadline, that will be what will be on the asylum officer's mind if they see someone who's passed. And so you want to really get that out of the way right away. So the affidavit addresses why this individual applied after the 1-year filing deadline right at the front. And then it goes into talking about how is he demonstrating to the adjudicator that he is indeed a gay man. And he talks about how he was persecuted as a child and then how he ultimately realized over time that he was gay and how did he get into romantic relationships. And in this case, the relationships that he got into involved victimization by an older man. And then, so it talks about how it really is helpful to include the full story of his harm that he experienced as a younger man. He experienced bullying from other boys. He experienced victimization from private individuals that weren't necessarily the crux of his persecution claim, but they established this societal discrimination that was really pervasive in his life. And then it goes into his first relationship, and so it's quite detailed, you'll see. And so as we're writing these affidavits, we balance putting in enough detail so the asylum officer realizes this person is credible, they provided a detailed account of their life that they then can repeat in detail in their asylum interview, and we can see, oh, this is consistent. This is something that they could only be able to tell me if these things had actually happened to them, with not putting in so much detail that the person who was maybe telling their story 5 years after the incident happened can't remember all of the details that are in the affidavit that you maybe presented 6 months after the incidents happened. And then also really helpful to get affidavits from others. So former partners confirming the relationship that they had with the asylum seeker, maybe people that were involved in advocacy groups that the applicant was involved with as well. And so, you'll go through getting that person to describe in detail how the person was involved and making sure that you can confirm their identity, getting it notarized or getting a copy of their ID. And you make sure that you get an original signature, and really you can get it signed by notary public, but if it's not possible, you can include a statement swearing that the statements were made under penalty of perjury, and then you want to make sure to include a statement if the applicant is not English as a first language speaker, stating that it was interpreted word for word to the applicant, and then having the interpreter sign that they are actually fully fluent in English and then the language that they're interpreting. Anything to add on affidavit?
Yeah, and in our step-by-step session, we go into a lot more detail about this, but it really depends on your client, too. There might be clients where you're exchanging drafts and you're putting comments on the statement that they're actually writing, or it might be multiple meetings with your client and they're telling you what they can, and it's going to take 3 or 4 meetings before they feel like they can trust you and tell you more information. So I think just being aware of that, and we try to prepare you for that based on what we already know about the client. But with all asylum seekers, it ranges in terms of literacy levels, education, language barriers. One of the other things when we think about that's really important for LGBT cases or cases where there's conflict within the country of origin and the type of claim is really being sensitive to who the interpreter is, because that can be one of the biggest challenges of having, oh yeah, I have a French speaker who will come in who's, oh, they're from your country, and they'll help interpret, and then find out that your client doesn't want to tell you anything, and realize later that they didn't feel comfortable sharing that. So really trying to work with your client in some of the conversations that are safer conversations with them to make sure that that they can confirm that they're comfortable with the person that you're using as an interpreter, and that's even more important in terms of LGBT.
So our client has drafted his affidavit, and I've reviewed it. As I'm working with him to finalize it, I mean, obviously it's written by an everyday person, not an attorney. As we work through that, how important is it to make sure that it remains in his voice? How much of it is important to make sure that it reads like a well-educated person in English would have written it?
Err on the side of their voice, and that's what legal briefs are for, to tie it all together.
Okay.
And even we in the other training we talk about danger zones in terms of, oh, what date did this happen on, and it took you 10 conversations to settle on a date. Well, let's try to find something a little broader to put in that affidavit that's something that they're going to actually remember. If they don't know the actual birth date of their child, it'll be in the asylum application, but not in the affidavit, and you can refer to the document. But if it's not something that they actually remember in their own memory, then working with them so it is. When we work with clients, we ask in the intake process, we ask if they're able to bring in a personal statement, and that's a really helpful. Well, this is what we start with. In many cases, if it's written by them. But then there's also issues if they have someone helping them, and then it's actually dissecting that personal statement, which was actually informed by many community members that told them these are really helpful things that should have happened to you, and getting back to that point of trust with your client to say, look, these things were written down. I want to know what happened to you, what is your experience, and what do you remember? We've had clients that have the timelines don't make sense, and they've been detained so many times they don't remember when or where, but they can tell you their visceral memory will be there, and the scars on their body, if they've been tortured, will be there and can help tell the story. And if that's all you've got, then that's what you run with and provide the context as you're able through other sources.
How important is it for them to very specifically say what happened to them? This is the second case I've worked on, and in both cases they wanted to say we or us or some people, and it was hard for them to get to I and me and what happened specifically.
Yeah, and that's a huge thing, particularly when clients are part of some broader movement and feel a lot of guilt that they're looking after themselves, getting safety here. But the officer in the interview, they're going to say, okay, I know you know about what's happening, and I know that it's a clip, but I want to know what happened to you, and really, that's a really important place to get and sort of understand the context of you helping yourself will help you help others later, but we want to focus on what your own personal experience was. That's a really good point. Yeah.
I think one thing I would just add that's specific for, or especially for LGBTI claims, is that your client's going to be someone that is not used to talking about, because in their own country it's been so taboo, and so being aware of that and being patient with that and working with like just planning that it might be multiple interviews before the person is comfortable enough to go into an asylum interview and talk about what happened to them.
Yeah.
And one thing that's really wonderful about Minnesota that's really unique to the state is that asylum seekers, once they file their applications, are eligible for health insurance, Minnesota Care, and so that really expands the therapy that is available to them, because they can then work with a wide range of folks, not just people who don't charge. And so you might experience many of your clients that before they have healed from the trauma, they cannot tell you their story without re-experiencing symptoms in a way that's really unhealthy for them, and interferes with their ability to go about their daily life. So really thinking about connecting your clients with therapy early in the process so that they're able to write an affidavit with you and tell your story.
I'll just also add that there's also taboo against mental health issues in many countries, and so when you're in the asylum process, actually that's the best way to get people to actually to say this is important for your case. That's a big incentive for a lot of clients to actually overcome that taboo and seek out assistance.
Yes.
As sort of a hypothetical question, if you could give advice to future asylum seekers, LGBT asylum seekers who are currently facing persecution in their countries, I've heard you already say a few things that I would turn into advice. So if you are attacked, go and get a medical examination and a certificate, go and report to the police and keep a copy of the report. If you're involved with an LGBT organization, have them write a letter describing their involvement. Are there other pieces of advice you would give to them so they can have as strong as possible a case once they're out of their country and seeking asylum?
Yeah, I mean, a couple of things. Save text messages, save Facebook messages, make sure you have a way to access those types of things. A lot of times people will throw away phones or delete their Facebook. Before you delete your Facebook, print it out, and then also figure out a way to maintain contact with people in home country who might be able to corroborate things. So a lot of times people will completely lose contact, and that's sometimes unavoidable. But if there's a way that you can get an email, from someone who's trusted before you leave, I do think too, accessing therapy, doing a forensic evaluation, doing things to take care of yourself that might feel selfish to people especially people who are separated from family or loved ones, like getting therapy so that you're in a position where you can tell your story and then have a way to protect those family members, because you were healthy and you were able to withstand the emotional and psychological rigor of an asylum interview.
Yeah, and just going back to the most important piece of information is the client's testimony. So, if they're have a notebook and they can just write down, and especially with claims that are more cumulative based, like when you have those nightmares that you're remembering what happened to you when you were 5 years old, write that down, because that's all going to be important and not as accessible when you're dealing with the trauma of being in a new country on top of escaping what you've gone through. So, to the extent that you can start writing your narrative, and then it'll piece together in some way later. Because, we often send clients with a notebook and say, okay, I know you can't remember everything now, but put this by your bedside, and when you wake up in the middle of the night because you have a nightmare about something that happened, write it down. So I think that's the other biggest piece of advice. So it looks like we've just got a few minutes left. If those are awesome questions. We love it when people are asking questions because we know that you're engaged. And we also know it's a lot of overwhelming information. But, like we said, we got hundreds of cases and other volunteers that have gone before you, so we are hopeful that it will be surmountable and lots of support from us and from other attorneys that are volunteering their times that know the ins and outs of it. So the one other thing that I wanted to mention too, especially if you've taken on a case, we have a coffee and case discussion series in the first Friday morning of each month. It's not intended to be a formal CLE, but more of a time to bring other volunteers working on similar cases or similar regions of the world together to answer questions that you might have and create a little information sharing among volunteers as well, because a lot of times we have cases from similar countries or similar issues, and you can be a support for each other as well going through the process. So
and one other initiative we just launched is that, sometimes it can be kind of a pain to send a bunch of emails to us to set up a check-in call at a time that works for you. So we have a third Thursday, 8:30 a.m. check-in call, so that if you just have general questions that are kind of piling up as you're working with your client, then that's a time for you and other attorneys to jump on a call with us and ask your questions, that you don't have to be shooting emails back and forth to set up a time with us. Although, of course, we're very happy to do that if there's questions specific to your case that you want to ask us.
Yeah,
question. I just have, I guess, a nuts and bolts question. It sounds like a lot of people already have cases, but like if people want to get cases, do you ask that they go to the step-by-step training that's coming up first, or do they just tell you they're ready? Or
I almost think that the step-by-step is easier when you have a case, because then you're able to work through the facts of the case that you're working in and apply it right away.
Mm-hmm.
This is a little abstract. I think the case samples are good, but when you already have a client and you might have more questions that are specifically related, you can apply right away.
Okay.
But if you also don't feel comfortable jumping in yet, you can certainly go through it without it. If you haven't already signed up on our website, there's a registration where we ask for your contact information, your attorney ID, and then we'll get you registered so you can get those monthly emails as well. And then I know at a lot of the firms for paralegals working with the pro bono coordinators, if you're interested in working on a case, and compare you with one of the attorneys, because especially at the firms that have that support, it's been really critical and a really great hands-on way to have paralegal and other legal support get involved in the cases. Yeah.
I was wondering, maybe this is less of an issue when people are getting cases through you guys, because maybe you're already trying to help outline for them what that particular social group ground could be. But something that's proved really difficult for me sometimes as I'm trying to learn asylum law and simultaneously receive cases is like trying to wrap my head around, because it feels like most of the ones I see mostly kids from Central America, so it's mostly like, most of the time I can't just like hang my hat on race or religion or political, like it's always a particular social group, and then I'm always dealing with that battle of like, has this already been designated? Can I put this person into a category that's already been sort of clearly laid out, which would make my life 1,000 times easier than like I'm trying to persuade them that the asylum officer or a judge of that. So is there like some handy dandy place where I can just, without having to start like digging into case law for hours on end that I don't really have, like is there a handy dandy place where I can see sort of some like outlines of social groups?
Yeah, I think our most recent Central America.
Yeah, we have a
case law review.
Yeah, we have a pro bono attorney asylum update, which has a case list, which we'd be happy to share.
Okay.
And then AILA has a really good free webinar where they talk about claims for individuals who suffered persecution by gangs, which is a lot of the kids.
Yeah.
And so they have some national experts who talk about what are different claims that they've made, what are kind of evolving arguments for kids as we're shot down again and again as we try to protect kids. What are new things that attorneys are presenting that have been successful.
Okay.
And then I had another idea. CGRS is a great resource too. They will do technical assistance phone calls where you can work through your particular social groups, and they'll say, oh, we know that this is working in California or in Iowa or in, have you tried this? Yeah, there's a lot of good places, and we're happy to give any ideas that we have.
And particularly for the novel claims, just always remembering that it is a case-by-case analysis, and even though it was shot down in one context and the odds may be against you, if you've got other information that really, and other evidence that makes the case, then it's worth trying to create that distinction and say, well, that record didn't have this, which is what I have that shows that it actually is.
There's a sense where you can feel, you're like, this should be an asylum case, but like, how can I flesh it out?
Yeah.
I suspect many ICE stops or frequent ICE stops are after hours or on the weekend. Do you recommend giving your cell phone then if they're to call you?
Yeah, I think it's case by case in terms of what you're comfortable with. I know a lot of clients will use WhatsApp too, which is a pretty safe way for in terms of connection. But and as alarming as that is, I will say that I can still count on one hand the number of clients that we have that were actually taken from an affirmative process or apprehended before they were able to file. So even though it's something we really want people to be aware of and know how to respond, we don't want to cause undue alarm, because at this point, at least, we're not seeing it happen on a really pervasive level.
I would say what we are seeing more is family members being targeted if people have undocumented family members. So making sure that if people have family members who are undocumented, they're getting consults. We have a list of attorneys, free walk-in clinics, so people can get information about what is available to them to protect themselves, and then can maybe have an attorney that they separately hire, so that they can call that person. Well, you don't represent them, right? So you might not be the best resource if they're picked up, but so that they can plan ahead for their family members.
Great. Well, thank you everyone for spending this chilly Friday morning with us, and hopefully we look forward to working with you on cases.
Great presentation.
Thank you.